We're back on the record on case number 12 CF 1083, State versus George Zimmerman. While we're waiting for some of the jurors to come back, will counsel please approach? that one.
Jurors are present.
Please be seated. Good morning, ladies and gentlemen, and welcome back. And before we get started this morning, I'm going to ask you some questions. If your answer is yes to any of my questions, please raise your hand. During the overnight recess, did any of you have any discussions amongst yourselves or with anybody else? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use an electronic device to get on the internet to do any independent research about the case? People, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. Mr. O'Mara, you may begin.
Thank you. Good morning. How are you? We're not the end of voir dire. That's the good thing about where we are right now. The other good thing, in one sense, is that we will have the people chosen for the jury, and the rest of you get to go home, but we will have our process truly begun, because at that point, we now know we can move forward with the presentation of the evidence, and that's what most people think trials are. No one really thinks about the time that has to be spent doing just this, but this is probably at least as critical, if not more critical, than the evidence, because if we don't get a jury who can sit fairly and agree not to bring in those pressures and publicity and all that we talked about for the last week or so, if you bring that into the courtroom, then what we cannot get is a fair verdict, whatever that is. So, more important than it might seem to you that we spent the last week going over all this, but a very important part of the process, and I appreciate you paying attention so far. Also to Mr. Del Rionda, and would appreciate the same consideration as I wander through some questions that we have. I'm going to ask for one agreement, and that is there are 40 of you. We don't even use your names, so there's nothing but numbers. And I'm going to have a very difficult time remembering numbers and all that. So, though my mother, rest her soul, would not be happy with this, I'm going to ask if it's okay if I point a little bit during this, rather than do this, which is the only other thing I can do. 14. So it'll be okay if I sort of take on the informality of doing one of these, if I need to. I apologize in advance, but it's just going to make it maybe a little bit smoother, maybe a little bit quicker, which you should appreciate. And we'll sort of start with that. I am, yeah, that was my second half. However, although I'm going to be informal a little bit, you would have to, when I say, if you would, sir, state your juror number, because she will stop me in a heartbeat of my informality if you guys don't play along with us, okay? So can we do that? All right, and I'll try to the ones that I have, but I just don't want to get caught up in either misspeaking your number or just wasting the time to try and find it when we all know what we're really trying to do, okay? It's interesting because one of the first things that Mr. Del Rionda said was that I represent the people of the state of Florida. I used to be a prosecutor, and I used to say that as well. But now, after doing this for probably 27 years, defending citizens, I also represent the people of the state of Florida. I just do it over, I guess, I don't know if it's been, I haven't actually done the numbers, 10,000? I don't know. I represent people of the state of Florida. I just do it individually. So we do it, and we do it because it's the path that we've chosen. Whether you're a prosecutor and decide to prosecute people for a alleged violation of a criminal law, or whether you do criminal defense work and you represent those citizens accused. And I have another concern, and that is that we have labels that we put on people. We talk about victims, and we'll talk more about that in a minute, and then we talk about defendants. I've got a concern with that word because that suggests what? What does defendant suggest to you, ma'am? Let's start right, though. Start right. Your number.
B51.
Thank you.
And it means that I'm having to defend myself.
Yeah, exactly.
I'm already in the wrong, perhaps,
Sure.
and because I have to defend it.
Sure. Like George, it's been called the defendant in the case, right? I'm George Zimmerman. I'm sorry.
Thank you.
I apologize. We have an agreement, and it's a proper one, even though I just asked for some informalities. It's not George, it's George Zimmerman, or Mr. Zimmerman. It's not Trayvon, it's Trayvon Martin, or Mr. Martin. And of course, it's Judge Nelson, and it's Mr. De La Rionda, and Mr. O'Mara. So I apologize for that. Obviously, I'm gotten to know him a little bit, and my informality with him should not fall over onto you. But Mr. Zimmerman is called a defendant, and as you say, as though he has something to defend. There are states that call them citizens accused. The people of the state of wherever, or the state of wherever, versus John Doe, a citizen accused. Tell me what you think about the difference there.
Citizens of the accused.
Just a citizen accused.
B51, sorry. Say that part
Sure.
again.
What do you think the difference is in context when you call somebody a defendant as opposed to calling them a citizen accused?
Well, it doesn't seem as inflammatory.
Great, I agree. Can we all agree that the word defendant, when used in this trial, is not going to be considered as any suggestion that he's done anything wrong? Any problem with that? Well, let's talk about it a little bit more. Ma'am? Thank you. He's here before you, charged with a crime. The state has decided to prosecute him for a crime. How does that weigh in your thought of whether or not he's guilty?
Well, basically like what we were saying yesterday, right now we should view him as innocent until we hear evidence otherwise.
Okay. Ma'am, what do you think about that?
K95?
Yes.
I would agree that he's presumed innocent until proven guilty by evidence.
Do you think that that is fair to hold the state of Florida to that burden, that Mr. Zimmerman stands before you, even though he's been arrested, even though they've decided to come here before you and charge him with a crime, that he's still innocent?
Objection, Your Honor, he's still innocent, he's presumed innocent.
He is presumed innocent.
As he is before you today, if I asked you for your verdict today, this minute, what would it be?
I have no verdict. K95?
Yes.
I don't have all the facts, so I do not have a verdict.
So if I told you guilty or not guilty, what would it be?
It would be not guilty.
Okay,
K95, sorry.
that's okay. So this presumption of innocence, first of all, anybody have a problem with that? Man, what do you think about the idea of a presumption of innocence? No, actually, just for a second, sorry. Yes.
What do I think about that?
Sure.
That's just the way the law is.
There are some
That's how-
countries.
That's how
sorry.
they protect the citizens of this country,
Okay.
instead of automatically automatically making the assumption that somebody is guilty. That just protects everybody.
There are some countries that have an opposite presumption. Once the police arrest you, you're presumed to be guilty of something and have to defend yourself. Has anybody had any exposure to countries or cultures that have an opposite? Ma'am, and if you would, your number?
E73.
Tell me your experience in that regard.
We lived in Singapore, and the justice system was very different there.
Okay, and I don't know it to be true, but is that one where once you're arrested, you have to present positive evidence of your innocence?
If you're even allowed, yes.
If you're even allowed. Well, I guess if I was a Singapore attorney, I would say, well, prosecutor's prosecuting you. A cop said you did something wrong, which is how the process may have gotten started. What's wrong with defending yourself? Explain to me what concern you would have with that system.
You have no idea whether or not the police were being just when they did that.
Okay?
So you depend on the police being just, which may or may not be the case.
Anybody else? Anyone else have any experience, sir? And if your number? Yeah.
I lived in the Middle East for the last 10 years, 2010, and I lived in Kuwait specifically, and the system works that way. When you get caught with whatever illegal substance or anything like that, you do get arrested, and you get sent to jail. Actually, you don't get to a hold up or nothing like that. You just go to jail, and until positive evidence is presented. And some Americans that I know did spend a lot of time in jail due to those things.
Even though they were never actually proven guilty.
Yeah, the consular used to get involved, and the embassy, and at that point things changed, but it was always that way.
Mm-hmm. Anybody else? Ma'am, yes, and your number?
Age 69. In South America, at least the country that I was staying at for a while, Venezuela, there is no police work, at least not here. So if someone accuses you of a crime and they arrest you for it, it's very difficult for you to prove otherwise. And depending on the crime that you commit, usually justice is taken into the police's hands, or not even the inmates, when you're incarcerated. So.
Okay. And there was another hand, I think. Yes, ma'am.
I'm 24. I, as a child, lived in a South American country that was under a dictatorship, and sometimes you disappeared and you never got back, and sometimes you weren't seen again for years and years. It has changed now, but still it leaves a lot to be desired.
My concern is going to sound sort of simplistic when I say it, but I just want to start with this as a base level. Are you certain, the five of you who said that you've had exposure to another system, a system almost in opposition to ours, that you don't think that that's a better system, or that that's a system that you would take on the precepts of? Any concern with that at all?
That's why my father came to this country.
Okay. Any concern, sir, that having your exposure over in the Middle East, that, you know, and you might just think that, well, you know, it's more efficient. It wastes less time. We don't have to spend any time in jury selection.
I think you start to appreciate what you have here when you see things like that.
Anyone?
Age 18.
Age 18. Anyone have any concerns then with this presumption that Mr. Zimmerman, any citizen accused, carries into a courtroom? Ma'am? Ma'am, how do you think that presumption of innocence then is overcome by the state?
E6. They would have to produce first-hand witnesses and facts to overcome any reasonable doubt.
So if I'm going to paraphrase what you're saying and see what other people think about it, do you think that the presumption of innocence then stays until the state overcomes it beyond a reasonable doubt?
Yes.
Okay. Sir, what do you think about that?
P35. I believe that a person is proven innocent until proven guilty, because the person that's accusing them has to prove what they did wrong. If anything other than that, to me, is pretty much speculation or guessing if someone did something, because you don't really know until the proof comes out.
And to the extent that Mr. Zimmerman enjoys this presumption of innocence, as we all do you believe that that can only be dissipated if and when the state proves their case beyond a reasonable doubt?
Yes.
And that until that point, he's still presumed innocent?
Yes, sir.
This is going to sound like a trick question, and it's not, but I want you to think about it for a minute. When, if at all, does the state prove their case beyond a reasonable doubt?
I guess once they present all the actual facts that they have in front of everyone, then we just weigh it.
The last part, what was that again?
Then we just weigh it, weigh the evidence, whether I believe it to be true or false or whatever.
The jury decides whether or not the state has proven their case beyond a reasonable doubt. Is that what you're saying?
Yes, sir.
Okay. Man right behind him, what do you think about that? This presumption of innocence, and it's staying in place until and unless the state proves their case beyond a reasonable doubt. What do you think about that?
I think it's a fair way of doing it. E22, sorry.
Any concern with holding the state to that burden? Sir, right next to him, your number?
B72.
Any concern with waiting until you decide as a jury that they've proven their case beyond a reasonable doubt for that presumption to dissipate?
No, I have no concerns. That's the way the system works. I've never questioned it.
So 3 days into the testimony, right? The third day is over. We're done for the day. Innocent? Presumed innocent? Still?
As long as the jury has to make their decision, presumed innocent.
Man, what do you think about that concept, this presumption of innocence?
G14.
No, but it's right behind her, sorry.
I-19. It's fine.
Okay.
I don't mind waiting to hear all the facts and base my decision off of that.
But are you okay with the concept that you're going to go through a few days of testimony and not hear it all yet, and you still have to stay in your mind that George Zimmerman is presumed innocent?
Yes.
Any concern with that?
No.
Let's talk about that concept of beyond a reasonable doubt for a moment. Mr. Delarionda talked about it a little bit, and I'll tell you that this is an area of the law where lawyers are told to be careful, because we love interpreting and we love talking about things and giving all these different examples, and the law says that only the judge can really give you a very, not precise, but a very, precise and identified definition of what reasonable doubt is. And to the extent that we talk about it here today, you need to defer to the court's instructions as to the definition of reasonable doubt. And Mr. Delarionda said, I'll tell you what a reasonable doubt is not. It's not a speculative doubt, imaginary doubt, or forced doubt. So, let's talk about speculation for a minute. Sir, what does it mean to you to speculate about something?
E54. Speculate means I don't know all the facts.
Okay. So that you have to add certain facts to it to come to whatever conclusion you come to?
Well, I couldn't add any facts. I can only add assumptions, that maybe inferences or something like that.
Okay. So if the judge were to tell you that a reasonable doubt is not a speculative doubt, what would that mean to you?
Well, it means I have to have all the facts presented to me. I mean, and I may not get all the facts. I'm only going to get the facts that are presented to me in this case, in this courtroom.
And how about, ma'am, with the term reasonable doubt is not a mere possible doubt? What do you think that is to get across to you as a juror?
37. Just that you have to be sure that all the evidence is in and that you're absolutely sure that you believe on all just the evidence, no opinions, no biases from anybody, no anything, that he's guilty or not guilty.
And who carries that burden?
The state.
Any concern with holding them to that standard?
No.
Sir, other things that it's not is an imaginary or forced doubt. So the judge just tells you a reasonable doubt is not an imaginary doubt or a forced doubt. What do you get from that?
B7, I remember when you brought that up yesterday. And then that one I was kind of like, I don't really know what they're trying to get at. The other ones I understood.
Okay.
This one, I was like.
Let's talk about it for a bit. Let's talk about an imaginary doubt. Let's just say that you listen to the facts of this case.
Well, when you say imaginary, so an imaginary doubt would be a doubt that I've just made up in my mind.
Right.
It's not based on that.
Sure. Would you agree that it would include a decision by you that you just want to find Mr. Zimmerman not guilty? You just want to find him not guilty. And then you make up a doubt in order to justify the verdict. Would that be what we're talking about as an imaginary doubt?
I don't know if imaginary means you're doing it to justify something.
Okay.
Yeah, certainly people will make justifications for their actions when there aren't.
Did you understand that if you did that, if you came up with a doubt?
I understand that that is not how you acquit or convict someone.
Okay. Ma'am, what do you think? Oh, you can drink your water first. Go ahead. Got you right mid-swallow, sorry. What do you think about this idea that in the concept of reasonable doubt, a judge will tell you, in effect, don't force a doubt. Don't come up with a forced doubt. That's not reasonable if you have to force a doubt to exist. What do you think about that?
B12. It means that if I don't have a decision, that I'm trying to make up a decision.
Okay.
And we're not supposed to do that.
And you understand that if you did that in order to find him not guilty, that would not be a proper reasonable doubt.
Yes.
Okay. Anyone have concerns now that we've talked about this concept? And I know we spend sometimes our lives dealing with these issues, and then we come to you one day and say, please catch up. But, ma'am?
If all the evidence is presented and they're trying to point it to one conclusion, but as jurors, if we could imagine a scenario that also fit with all the facts presented, that would be a reasonable doubt?
I'm not going to define it, but let's talk about something that might help. And we're going to come back to reasonable doubt, so those of you who thought we got away from it, we're coming back to it. But I want to talk about something you just brought to mind. Mr. De Leon just said to you, there's direct evidence, and then there's circumstantial evidence. Right? Remember that? And is that sort of what you're talking about? This idea that maybe there's another possibility?
Yeah.
Okay. Direct evidence is, you wake up in the morning. Well, let's do it this way. Give me an example of direct evidence.
First-hand, someone that has first-hand knowledge, facts.
Okay. I have an iPad in my hand. If you see it, what's that?
I'm a first-hand witness.
It's direct evidence, right? You can see it, feel it, touch it, understand it, and it's really not open to interpretation, is it? I mean, maybe it's not an iPad, and you have to have other evidence to show it's an iPad, but it's what you see and feel and hear, right? And then he also talked about circumstantial evidence. I'm going to disagree with him a little bit in definition, and the judge will give you instructions, particularly on this issue since now it's been brought up, as to what circumstantial evidence is. So I thought Mr. De Leon just said they're one and the same. I don't remember if that's exactly what he said, but let me drill into it a little bit. What do you now have as a working knowledge of what circumstantial evidence is?
I guess it would just be other facts that kind of fit in with what it's.
No, first of all, you're doing great, so keep going, and do not believe that there's some correct answer to this.
I guess someone saw something, but it may or may not have. It may or may not be. You have to draw inferences. What I
exactly. Think. I think you said that yesterday. You looking at circumstantial evidence, you have to draw an inference from it. And the example that was used was, I come home, cookie jar has been invaded, and I look at my two daughters, and one of them has a crumb right here. Well, pretty strong circumstantial evidence. She's the one who took the cookies, right? And I think that was his example, right?
Right.
Okay. What do you think about that?
Well, I think it doesn't prove it. Absolutely.
Sure.
So.
And here's the thing. Circumstantial evidence, to be believed by you, you have to make certain that it does away with every hypothesis of innocence. Do you understand what that means?
There couldn't be any other reason for that.
If you're going to rely on circumstantial evidence, which you're allowed to do, it has to exclude possibilities of innocence. And what do you think about that concept of circumstantial evidence compared to direct evidence?
E40. I think both types of evidence are important. I think both types are important to listen and make that differentiation between what was presented as direct evidence and what is circumstantial. And I think the jury needs then to put those together or have them mesh or not mesh with each other to really get that fuller picture of maybe what the truth was at that time.
Okay. Ma'am, yes.
B37. Isn't circumstantial evidence based on direct evidence or no?
I'll give you an example. You wake up this morning, you walk outside, and your lawn is wet. What is that circumstantial evidence of?
That moisture has come to your lawn somehow.
It rained, sprinklers came on, there was a flood overnight or something, right? So it gives you an idea, and you can draw an inference from it. You might say, oh yeah, it rained last night, or you might say, forgot to turn off the sprinklers. But it doesn't tell you a fact that you can conclude in and of itself, does it?
No.
Okay. So when you say that circumstantial evidence is based on direct evidence, I'm not exactly certain what...
Not based, but supported by.
It, as you said, it might be, but what if it's not?
Right.
So if the decision to you was, tell me how your lawn got wet, do you have an answer on that one piece of circumstantial evidence?
No.
So by itself, that's not dependent upon or doesn't come from direct evidence, right? Because you don't have it. Now, if I ran in the middle of the night and said it's raining outside, and then you woke up, now you have some direct evidence, right? I told you it was raining, and then you see the wet grass. Obviously it was raining. In that sense, would you agree, it's dependent upon some direct evidence, but they're separate categories. Anyone, ma'am? Oh, a hint along the way, if you shake your head in agreement or in disagreement, I'm probably going to call on you. So, well, I'm telling you now, I have a while to go yet. E28? Okay. What are you thinking about that concept?
Well, you would have to not be able to hold that much credibility, I guess, to circumstantial evidence.
Because why?
Because it's circumstantial, there's nothing that you can actually prove.
Okay. And it may not, continue just a second, it may not in of itself exclude a reasonable hypothesis of, come on, I said it 3 times now. Of what?
Innocence.
Of innocence, right? If it doesn't exclude a reasonable hypothesis of innocence, you need to be very careful with it. You won't.
Well, I was just, E6, just going back to with the wet lawn, even though the husband came in and said it's raining, perhaps the sprinklers came on afterwards. I mean, it would have, that it's still, you couldn't make a sure conclusion.
Agreed. And yes, sir, ma'am, yes.
I-24. What if, going back to the cookie jar,
Sure. I wasn't leaving that behind either. Go ahead.
okay. The brother or sister broke the cookie jar, took the cookie and said, look, here, you eat it.
Have a cookie.
Have a cookie.
Sure.
How many do that?
So,
how do you deal with that?
Had Mr. Del Rionda prosecuted that one daughter with the crumb, based upon that circumstantial evidence, could he have been wrong?
Yes.
Did he rely on evidence that wasn't direct evidence? He didn't ask her if she had done it. And that he presumed information without having all of the evidence.
Yes.
And what if you do that?
I hope I don't.
I really hope you don't. So, any concerns about, ma'am?
B76. So it sounds like circumstantial evidence is not the only thing, that you would need some type of definite, something that leads up to something definite. So it wouldn't be based on just circumstantial?
Well, and the judge will instruct you, but the concept is that when Mr. De La Rionda says to you, there's direct evidence and circumstantial evidence, and direct is just, I have an iPad in my hand, and circumstantial is crumbs in the lip, that you need to look at that with caution. You need to look at that and say, does it match everything else, and does it exclude every reasonable hypothesis of innocence? So a case that is just built on circumstantial evidence, how would you look at that case? Nothing but circumstantial evidence, as opposed to a case that has nothing but direct evidence. How would you look at those two?
Innocent if it's just based on circumstantial, but with direct, then it would be.
The beauty of all this is, one, you don't need to convince or decide it with me in my conversation with you. You're going to have to with your other jurors, but the judge will give you some instructions. It's not a law book. It's not 600 pages to try and get to all these concepts. But what we've done is we've taken the jury instructions and tried to make them sensible to those who don't live the law like the rest of us. And you're bound by that. So when you look at it, you read it, and you apply it. Any concern with that concept on it? Because you could look at that and say, I see some circumstantial evidence, I see some direct. I'm confident. I have no doubt to which I can attach a reason that he's not guilty, so I can find him guilty, based on whatever. No one's going to go up and say, okay, this part, this is direct evidence. Ready? We're not doing that. It's you who will determine as the jury what circumstantial evidence is and what direct evidence is. Well, we're talking about it now to give you some insight on it. Ma'am, right next to her.
B29.
You just look so comfortable. We've talked about this direct evidence, circumstantial evidence concept. What do you think about it?
I think you really can't make a decision on anything until you hear everything.
Okay.
I mean, I hear everything you're saying, and I understand all the if and buts. But at the end, I would have to wait to the end.
Okay. And let's go back for a moment to this reasonable doubt concept that we talked about. We talked about what it's not, right? It's not something that you have to force into it as though you just want to find him not guilty, you'll force it or you'll make it up as imaginary. First of all, are you okay with the concept that that is not a reasonable doubt?
Yes.
Something that you have to force to happen?
Yes.
Okay. The judge will also tell you that if after considering the evidence, comparing it and weighing it, so you've looked at all the evidence, you've heard it all, you've weighed through it, you've thought about it, you've figured out what's circumstantial and what's direct and what weight you're going to give to it. The judge will tell you that if you have there is not in your mind an abiding conviction of guilt. She's not going to define abiding. She's not even going to define conviction. But she's going to tell you if you don't have an abiding conviction of guilt, or even if having an abiding conviction of guilt, look at the evidence, figure it out, weigh it, and either you don't have an abiding conviction of guilt, or even if you get to the point where you go, I have this abiding conviction of guilt. I really think he's guilty. But that abiding conviction of guilt that we're now talking about, it wavers and it vacillates. So get to the point, way at the point where you have an abiding conviction of guilt, but you say to yourself, maybe not. Maybe my abiding conviction of guilt isn't right. Maybe I'm wavering in that decision. Maybe I'm vacillating, right? So let's say you get to that point. What's your verdict? You're not supposed to know yet because I haven't told you, but I want to know what you think your verdict should be if you have an abiding conviction of guilt that's wavering.
So B29. So what you're telling me is, if I'm feeling in my mind,
Yeah.
in the back of my mind,
Yep.
a little
Something.
guilty. But
more than that, you have an abiding conviction of guilt. You've gotten way past maybe. You've gotten to the point where you have an abiding conviction of guilt in your mind. You're getting there. But that abiding conviction of guilt, and you get to define that, I'm not going to, and not even the court is going to. But when you get to that point, that abiding conviction of guilt point, it's wavering and it's vacillating. So now you're at that point. Tell me what you think.
Your Honor, I'm going to object. It's not stating the whole instruction is beyond a reasonable doubt. He's misstating it.
We'll get to it. I think this portion of the conversation is going where I want it to.
Okay, and I'll just instruct the jury that at the end of the case, I will give you jury instructions, and that is the law that you will apply to the facts of the case. You may proceed.
Did you understand where we were before that?
Yeah.
Okay. So you have this abiding conviction of guilt, but it's wavering and it's vacillating. What do you think about that?
I'm going to have the same objection in that he's trying to get a commitment from the juror as to only half the instruction. It's improper.
Would counsel like the court to read the instruction to
I
the
would,
jury?
Your Honor.
And then you can go forward with your...
You want me to read it?
I would prefer to be the one who
Yes, ma'am.
reads it to the jury. Can you give me a copy of it? I don't
Yes,
have
ma'am.
my
On my
instructions
purse.
with me. Yes. Thank you.
May I stand here?
Yes. Ladies and gentlemen, if you are selected as a member of the jury and we have finished all of the evidence in the case and the parties have rested and the attorneys have given their closing argument, then I would read the jury instructions, which is the law in the case. One of those instructions is as follows. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable.
Thank you, Your Honor.
You're welcome.
She sort of let you off the hook a little bit, didn't she? So, I'm sorry?
Said not guilty, B29.
Any concern with that? Any concern with the fact that you have gotten to the point of an abiding conviction of guilt, but it's wavering, it's vacillating, it's not stable, and therefore you must find the defendant not guilty? Any concern with that?
No.
Ma'am, your number? Any concern with what we've just talked to her about, this idea of this standard that the law holds the state attorney's office to?
No.
So if you have an abiding conviction of guilt that is wavering and is not stable and it's vacillating, what do you do with that?
I would have to return a vote of not guilty.
Any
It would mean
concern
there's
doing
doubt.
that?
It would mean that I have a doubt.
This is the time to talk about this. So there's no right answer. There's no you get on or don't get on because of how you answer this question. But we want to make sure that what we do every day in our lives, and you don't, gets communicated in a way that you can do what we're asking to do, to apply it. And we'll talk a bit more about that in a second. But anyone have questions? I would tell you that third-year law students don't get this. So it's okay if there are concerns with how to absorb this and to apply it. Sir, your number?
Sorry, G63. You stated that that you wouldn't define the word abiding in this context, and that nobody would, in fact. And in my understanding of abiding doubt, it seems to me that it wouldn't. It's a conflicting statement to say that you can have you have an abiding conviction of guilt, but also have that conviction wavering. It seems to me that that's in conflict, which means to me that I might not have the same notion of what abiding means.
Mm-hmm. And that's why there will be 6 of you. And that's why we spent years coming up with what we hope to be an instruction that you can apply. We can't define every word within it for you. That literally, when, the concept of a jury is a jury of a person's peers to look at what happened and to decide how society is going to react to that. And you guys, whoever's going to be on the jury, will be that microcosm of our society. And you're going to have to read that instruction, resolve the differences, and apply it. So I can't, it wouldn't be proper if I tried to give you Webster's definition of abiding, and the judge will even tell you don't do that yourself. Read it, understand it as best you can, and then apply it. Any concern with that sort of overview of why we do these instructions the way we do?
No, I think I understand that.
Okay. Other concerns or questions about this concept of the standard that we hold a prosecution to in our country? Any problems with to applying it? So what do you think about this whole idea of where we are with this reasonable doubt standard? You? No, don't. It's you.
Page 29.
Sir.
I'm a mechanic, so until you say your last words, sir, he is presumed innocent until that moment. I go back to the cookie jar, and I'm glad that the lady brought it up, because I was wondering about the other kid being smarter and knowing how to, hey, dummy, here, eat the cookie before Dad gets home.
Or just being nice and sharing the fruits of the crime.
That's true. That's very true.
Okay. Do you think it's appropriate that we place such a high burden on prosecution in a criminal case?
Yes.
Why?
To presume that he is innocent.
Why? Why put that burden on the state?
Because I don't live in another country.
Okay. Did you say that you were involved in a civil suit in the past, or that you sat on a jury for a civil? Without taking the time to look at my notes, those who have sat on a civil jury, if you just raise your hand for a moment. I thought there was one or two. Sir. Okay, well then I saw him first, so you get opted out on this one. Do you remember in the jury instructions that in the civil case that they would have told you that in order to make a decision, you need to make a standard of a preponderance of the evidence?
I-29, and yes, I do.
Okay. And do you remember?
Not I-29, I-5.
It's almost like a stealth juror or something. Somebody else's number. So in that jury, you were told that, in effect, in order for one person to win and one to lose, it has to be what we call a preponderance of the evidence, a little bit more than 50%.
I object at this time as to relevance. It's not a standard that the court's going to instruct.
I'm going to let him go further.
Thank you. You understand that in the civil context, it is the preponderance of the evidence, sort of 51%. Is that what they told you or they instructed you at the level?
They didn't put a specific percentage like the 51%, but it was the preponderance of the evidence.
And let me back up a little bit, because they didn't say 51%, and it's actually 50% plus a micro dot, right? I mean, it's just somebody wins, somebody loses, and you decide who wins and who loses, right?
the somebody wins, somebody loses is correct, but they didn't try to define by a percentage or small. We didn't do it that way.
How did you look at the preponderance of the evidence standard when you applied it?
Well, we had a lot of evidence. We had both direct evidence and we had the circumstantial. And there were 12 of us, if I remember correctly.
Let me stop you there. I'm not going to let you invade the province of that jury.
Correct, Your Honor.
Okay, so let's be careful.
So it's just a long process.
Okay. And in this case, we have a standard called beyond a reasonable doubt. Well, let me ask you firstly, do you think that the standard in the civil case was less or equal to the standard in a criminal case?
Well, as jurors, we considered it, well, at least I did. I considered it to be the same.
Okay.
I didn't see a difference.
Okay. Let me ask you, sir, what's your number?
B7.
In a civil case, if it's a preponderance of the evidence, do you think that in a civil case it should be a lesser standard or a standard equal to a beyond a reasonable doubt standard?
Do I know what I think it should be or what it is?
Well, let's talk about both.
Because, yes, there is a higher standard in a criminal case than there is in a civil case.
Why?
Well, I think there's more on the line. Civil case you're talking about, I assume property, I don't think there's jail time or any punishment of that sort. It would all just be material.
So would you agree, in order to take somebody's money, you would just have to win by a little bit? One person wins and the other one loses, and you get to take money.
I've never been comfortable with the lesser burden in a civil case. I understand why a high burden needs to be in a criminal case, but I think that same burden should be in a civil case personally.
Okay.
But I know it's law.
And tell me why should George Zimmerman enjoy a higher standard in a criminal matter than he would in a civil?
Well, it's, I think the stakes are higher. I don't know what, the punishments are in this case, but, from experience.
Well, let me ask you this. Would you agree that in a criminal case, liberty is at stake?
Very good.
Okay. And in a civil case, money is at stake. Any concern with that as sort of a starting point?
No, that makes sense.
Okay. Ma'am, what do you think about this concept of the preponderance of the evidence standard in a civil case compared to the beyond a reasonable doubt standard in a criminal case?
E13, I agree basically with what you just said, how civil is more money, and that aspect for this is determining someone's, I don't really know how to put it into words.
Potentially taking away their liberty.
Yes.
Okay. And you think that we as a society should have a standard that's higher if you're going to take away somebody's liberty than if you're going to take away their money?
Yes, I agree.
Would you have any concern then applying the standard that the judge tells you to apply, the beyond a reasonable doubt standard, as opposed to just looking at the evidence saying, yeah, I think it's, all in all, it's more in favor of the state? So any problem with holding the state to a burden that says if you have any reasonable doubt, the case has not been proven against a citizen accused? Ma'am, what do you think about that?
E28, no, I would have no problem with that because, like you said earlier, it's taking someone's liberties away versus property.
But why not? Let me ask you this. Let's say that we were here today, right now, and the state was going to present the same exact evidence that they're going to present now. Same exact evidence. But what they want to do is they want to get money from George Zimmerman. That's their purpose. It's a civil suit and they want to get money from George Zimmerman. Under that standard,
I'm going to sustain the objection because the state doesn't file charges
not.
for people for money. So
Of
if you want to name
I'll
a
use
John
another
Doe.
plaintiff. I'll use another plaintiff.
Thank
Let's
you.
make believe that they're not well, they won't not be prosecutors for a moment, so let's put people in their place. It is John Doe who is trying to get George Zimmerman's money for the same facts. Did it happen? Should it have happened? Was there a defense to it happening? All of that same evidence is going to come out. Under that standard, in order to take money from George Zimmerman, you only have to believe by preponderance of the evidence. Would you agree? That's the civil standard?
Yes.
Okay. You just got a little bit more than half. Whatever that is, you guys decide. So you can look at the evidence and say, under that standard, I'll give John Doe the money. A little bit more than half gets the money, right? Yes. And the evidence could convince you of that, right? Yes. Okay. What do you do under the same exact facts, the same exact circumstances, the same witnesses, but now your verdict has to be based upon a beyond a reasonable doubt standard?
It would have to be, excuse me, not guilty because it hasn't been proven without a reasonable
So
doubt.
they might have met the burden to give money, but certainly not to take liberty.
Yes, exactly.
And do you agree that there should be a difference between those two?
Yes.
Tell me why.
Once again, taking away someone's liberties versus money or property.
Sir in the back, your number.
H81.
We've talked a lot now about this standard and the differing standards. What do you think about the idea that under the same set of facts, money can be taken, but liberty cannot?
I agree with the other jurors that it's a higher standard because there's much more at stake.
Any concern with being able to hold the state to that higher burden in this case?
No.
I'm sorry, ma'am. Thank you very much, Ron.
Hi, I'm sorry, age 69. I believe this is what you're getting at, but it's really comparing apples to oranges when you're looking at a civil case versus a criminal case. In my opinion, it seems a little bit improper to compare the two.
Okay.
Because a civil case, you have evidence on both sides in a criminal and civil case. However, in a civil case, it's just different type of evidence entirely. And you might not have the circumstantial evidence. You can try to, but it's not the same as a criminal case. I think there's a very big distinction. And I believe that's what you're trying to establish, that a criminal case, due to the nature of the crime, or any crime, you have to be absolutely certain that the person is guilty. You can't just say, well, it's kind of leaning over toward they are guilty, so let's just say they're guilty. I think that's what you're hinting at, but it's really comparing apples and oranges.
Okay. I guess my concern is I want to make sure that when you go back and start deliberating, that you don't mix up the apples and the oranges.
Right.
Because if you do, if you infect your verdict with a lesser standard than beyond a reasonable doubt, then you don't have a just verdict. I don't care what it is. You will not have a just verdict. Do you agree with that?
No, I agree with that. It's just, it seems a bit, seems like we're pulling teeth here. I can't find another phrase, but it really is comparing two separate natures. One is criminal, one is civil.
Well, do you agree with the concept, though, that if all of the evidence was exactly the same, witnesses said the same thing, direct evidence was the same, circumstantial evidence was the same, that you could find that the burden was met to a civil standard, but still not find that it's been met to the criminal standard under the same set of facts?
Right, I understand what you're saying, but in reality, the evidence would not be the same. You know, you can't have the same amount, you can have the same amount of evidence, but they won't weigh the same in a civil case.
No, I see what you're saying. And my focus right now is just making sure that you understand the distinction between how you sit as criminal jurors and how you might sit as civil jurors. Yes, ma'am.
E6, I think just the repercussions of a guilty verdict in a criminal case follow you for the rest of your life. You have liberties taken away, and there have been people imprisoned that were not guilty, and that's why our legal system is the way it is, to avoid that, even though it still does happen. But nobody wants to live with the fact that they sent someone to prison for
And do you think it's a proper goal that we require prosecution to prove the case beyond a reasonable doubt to make sure that that doesn't happen?
Absolutely.
Anyone have any problems with that concept? That part of the reason to accomplish a verdict only to that high standard is to make sure that we protect the rights of the accused, but also to make sure that we don't send somebody or take their liberty improperly. Anyone have any problems with that? Finish up with the rest of the reasonable doubt standard, because the judge will tell you as well that a reasonable doubt can come from the evidence itself. You look at it and say, well, I have a doubt as to what happened, how it happened, if it happened, when it happened, or why it happened. And she'll also tell you that it can come from a conflict in the evidence. So you look at the evidence, and one piece of evidence says this, another piece of evidence says this, and you look at it and say, that's in conflict. Try to resolve it if you can, but if you can't resolve that conflict, the judge can tell you that that may well be a reasonable doubt to come from a conflict in the evidence. Any problem with that? Sir, in the back?
87. No, sir, I think it's one yesterday we brought up. That's when you use your good common sense and figure out what the heck happened best you can.
Also tell you that it can come from simply a lack of evidence. Anybody have a problem with that? Man, what do you think about the fact that you may get to the end of this and just not have enough evidence?
B51?
Yes. I'm sorry, the one in the second row. Apologize.
K95?
I should be more aggressive in my pointing. I apologize.
I'm sorry, could you please, K95?
Sure.
Could you please repeat the question?
The judge will tell you that reasonable doubt can come simply from a lack of evidence. So you get to the end of the case, states put on their case, and you just don't think there's enough evidence to prove to you beyond a reasonable doubt that anything happened here. Any problem with applying that concept of our law?
No, sir.
Mr. De La Rionda said that this is your opportunity to live the Constitution and complete, utter agreement. You know, it's a document, been around for hundreds of years now, survived wars. Heck, what is it? Windows 8 now, and there's probably been 30 versions of Windows, and yet only a few amendments to the Constitution. So yes, this is your chance to live it. It is your chance to breathe some life into it. And of course, I'm certainly not going to read it all to you. I think we all know generally what it means, how it gave us the liberties and the freedoms that we live by today. And then there's the amendments to it, the first 10 called the Bill of Rights, and we talked about those a little bit. Mr. De La Rionda talked about the reason why there are a bunch of cameras looking at me, not at you again. We had to clear that up with one juror. You guys are not on TV and will not be on TV by court order, so it probably stops about here. But they do have the right for this. That's their First Amendment right to freedom of press, freedom to speak, freedom to protest, freedom to talk and say whatever you want without worrying about whether or not you're just going to get picked up by the cops and put in prison without any further due process. And of course, the Due Process Clause tells us exactly how we'll handle that, make sure that we all get treated fairly and equally. Talk about a couple of the other amendments. The Second Amendment, of course, Mr. De La Rionda talked about that and said you have the right to bear arms. We talked about that a lot. Anyone, and I think what he said was, anyone have a problem with the Second Amendment? And nobody said anything. Well, you know, what's nice about the First Amendment is that you get to complain about the Second and all the other ones if you really want to. So I think probably why they said it first. If they put freedom of expression at the end, you might have a concern over whether or not you should be talking about the first 9. But you have the right to oppose what the government does, what the government says. You have to do it peacefully, but you're allowed to. So, I want people, if you will, I don't want you to make it up, but I want people to evidence some concern if you have it over the Second Amendment. So I don't want anyone to just say, forefathers, right? Everyone good? And then walk past it. Nobody has any concerns with the fact that you have a right to bear arms in this country? Ma'am?
I have a right, I have an issue with what kind of arms you're allowed to bear.
Okay. Assault weapons. Okay? It doesn't say assault weapons in the Second Amendment, but it has been interpreted by some to say anything. So sure, that's a concern you have. Anyone else concerned? Ma'am, yes.
E40. I guess my concern is there's a responsibility attached to bearing arms, an accountability responsibility, maybe a process around that, rather than just a blank statement that maybe doesn't flesh, well, it doesn't flesh it out, but I think that it's incumbent to flesh that out more to protect folks and to kind of put some definition around what that meant.
And we have, haven't we? We don't let children have guns, correct?
Not
Do you think
intentionally.
You think, well, not, yeah. Do you think that that's an appropriate restriction?
I believe that's one,
Okay.
yes.
We tell that when people want to use a concealed weapon, that they have to go through some training. Think that's okay, that we have that restriction?
Yes.
So what do you think about that? That you have to have some training if you're going to walk with a concealed weapon?
I think that's appropriate.
Okay. Yes, ma'am.
B37, I think the training that you get with a concealed weapon is not adequate.
Okay.
If you've ever gone to get a concealed weapon permit, it's like, that's it?
Mm-hmm. So you think that it's just given sort of short shrift and that you can get one pretty easily?
It should become harder.
Okay. Anyone else?
I'm
Just,
75.
ma'am, yes.
I'm 75. I know we're talking about the Constitution, but there's reasons that states and the federal government also put laws into place to kind of regulate arms as well, because the Constitution is such a broad statement that it can be misinterpreted. So you do have to get the concealed weapons training, and you can only use certain arms and things like that, but you have to also take a look that there are other laws in place.
And it makes perfect sense, doesn't it, that we look at it because, as we've said, the Second Amendment doesn't mention concealed weapon permits, does it? But our states have said we're going to give some vitality to the Second Amendment, but we have to understand the society that we live in, right? And that we're going to have some restrictions. Felons are not to have concealed weapons permits, right? You have any problem with that?
No.
Right? Okay. So, any other concerns with the way the Second Amendment is from two and a half centuries ago to how it's applied today? Any problems or concerns? Having said that, and if you do think that it's just too easy to get a concealed weapons permit, if someone has one, will you agree that it is a lawful activity?
It is.
Okay. And that personal position that you have, which we're all entitled to, that would not invade or infect how you would view the facts of this case?
No.
Because that's really what this process is all about, and that's why I want to have these conversations so that we vet some of this out. So, the fact that you think concealed weapons permits are too easy to get, will you then look at that and say, well, concealed weapons permits, I don't like them, or will you just follow the law as you're given the instructions?
B37, I just follow the law.
Right.
Just because you have a concealed weapons permit doesn't tell you how responsible a person is.
Another one, and then we'll move on to some other areas. Any other questions or concerns about the Second Amendment and its application? Great. The Sixth Amendment. I'll read it because it reads a little strange the first couple of times. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. That's what we're having here today, of course. By an impartial jury. That's what we're trying to do. I said in the beginning of at least several of your individual voir dires, if we can just say you promise to be fair and impartial, then we're done. But unfortunately, we just need to know more to make sure that that decision is not just a goal of yours, but something that you can accomplish. And here's where we get it from. The Sixth Amendment tells us that he has an absolute right to have an impartial jury, somebody who's not going to bring in their predispositions, whether it's from what we just talked about, or pretrial publicity, or anything else, and try this case, facts, the law, and ignore the outside pressure. Impartial jury of the state and district, Seminole County, wherein the crime shall have been committed, which district shall be previously ascertained by law, and he has the right to confront the witnesses and to have process. But mainly what we're talking about is he gets a fair trial. And that's why, first of all, we have a jury, and that's why we spend all this time talking to you. It's, again, overly simplistic to say, does anybody have a problem with the Sixth Amendment, the right that we all enjoy to have a fair trial by a jury of our peers, and that the law will be applied fairly to all of us. No concerns? Okay. We had talked about this apples and oranges difference between the differing standards. And I want to see if we can give a little bit of life to that. So in your daily life, when you got up today and decided what you're going to have for breakfast, how'd you make that decision?
Age 69, last night, I made the decision.
Okay. And how much effort did you give it, and how much consideration did you give it, and how much thought did you give it?
Not much.
Okay. Would you agree that we make most of those decisions almost automatically?
About breakfast, yeah.
Yeah. What way you came here today, maybe what you would wear?
Right.
Okay. And that's just sort of a default way that we just live our lives?
Get sucked into a routine sometimes.
I'm sorry?
You get sucked into a routine sometimes.
Sure. If I were to ask you, now that we've talked about these different standards, and I said to you, okay, which standard did you apply to making a decision what you were going to have for breakfast? Would you say it's more the preponderance of the evidence standard that I just said it's either oatmeal or it's cornflakes or it's eggs? Or what if I asked you to compare that in the standards that we've talked about, what would it be?
I'm not sure. That would be a great comparison.
That's why I picked on you, because of the apples and oranges, just so you know.
My decision on what I ate this morning was very simple because of my condition. So
Mhm.
it was actually a little bit more thought out. I know I can't just eat whatever I want if I want to actually have a day.
Okay, I'm going to come back to you in a minute. I'm going to go to the gentleman right to your left. Sir, you know, we've now talking about sort of what we do is everyday life. Like, did you decide what you were going to have for breakfast today?
You're asking me,
Yes.
81. You're asking me how I decided?
Sure.
It was automatic.
Okay.
Just routine.
Would you agree that that was sort of like a preponderance of the evidence standard? You just sort of decided one or the other, whatever it was going to be, and didn't give it much thought?
I'm not sure I would compare it to preponderance of the evidence, but it was a very low automatic standard, just something that I did intuitively.
Okay. Well, let me ask you this. In the past 24 hours, give me an example of a decision that you made that you would say is close to a just more than 50%. I just decided I'll do this rather than that. In the past 24 hours. Let me give you some examples.
No, I have one.
Okay.
I'm working on a marketing campaign and decided that what was proposed by a marketing colleague was insufficient for our objectives. And I relayed that information.
Okay. Okay. Now let me ask you this question. how you make decisions on a daily basis. Just sort of those rote decisions. I'm talking about the one in the second row. So yes, K95. This concept of just making decisions a little bit more than half. Tell me one that you've made recently that you would say is just one over the other.
What I was going to make for dinner, depending on what I had available.
Okay. All right. Fair enough. I think I made a decision today. I had a couple seats. It was one or the other. This one won. Would you agree that that's sort of a preponderance of the evidence standard? You just picked one over the other?
No, not in my case. K95. I'd have to make sure we fit. Some clothes fit. Some I just can't pick something out.
Okay. I don't know how to say that my suits fit. But okay. All right. I want to talk about
You have a hand up over here.
Sorry. Thank you. Yes, ma'am.
I was just gonna interject, put in, I have to decide what's available and how much time it's gonna take and how much time I have.
Okay. Makes sense.
Will I make it in time? Won't I make it in time?
Okay. Now, how about more significant life decisions? And I said I would come back to you. Are you married?
Yes.
And you've made a decision to get married?
Yes, age 69.
Okay. Tell me how you came to that decision to get married.
I took a little bit more of a radical step because my now husband actually lived overseas. So to ensure that our relationship would actually be functional in person, I left my job for a while and went to live in South America just to see how the relationship worked out in person as opposed to just online.
Great. And did you give that decision thought?
Absolutely.
Did you weigh the alternatives?
Yes.
Okay. Think it through a lot?
As far as moving to another country?
Sure.
Yes.
Okay. Do you think that the time and effort that you spent on making that life decision was closer to the preponderance standard, the apples, or closer to the I want to be certain beyond a reasonable doubt standard before making a life change decision like that?
Certain beyond a reasonable doubt standard.
Okay. And so let me ask you, tell me a decision that you made in your life that reached close to this level we've been talking about, this beyond a reasonable doubt standard.
Age 29. Never knew I'd have to think of preponderance for breakfast. But in my case, obviously with work, I've had to make some decisions to accommodate.
And are those decisions where you've weighed the alternatives and researched it as best you can?
Absolutely, because I have to be here. So it's forced me to make accommodations for people that I needed to help.
Any concern with being able to apply that concept, but our standard of beyond a reasonable doubt, to how you view all of the evidence and how you view all of the testimony in this case? Any concern at all?
Mr. O'Mara, is this a good time to take a 15-minute recess? Somebody needed to.
Yes, ma'am.
Okay. We'll go ahead and take a 15-minute recess. Please follow Deputy Jarvis out of the courtroom. Please be seated. Court is back in session. Once they're lined up, do you want to bring them back in?
Yes, ma'am.
Our jurors are present.
Please be seated. Mr. O'Mara, you may proceed.
Welcome back. And hopefully everyone's sort of staying as warm as they can. What I was gonna say in the beginning was that I'd actually tried my first case about a mile away over 30 years ago. Actually, so did Don West. And it sounds like we're going back to the 40s or 50s, but I tried it in a courtroom that didn't have any air conditioning. And I was going to, complain about that, but I'm thinking that some of you guys wouldn't mind having a lack of air conditioning. To the extent that you're really uncomfortable, I know the judge has said we're doing the best we can with it. I guess it's better than being warm because at least it probably keeps you more awake than otherwise, even if I'm not, and maybe the AC will. So I appreciate the attention you've given me so far. I'm going to continue on. I just want to follow up very quickly on this last issue. Then I think we've probably talked about reasonable doubt enough. I'm sure we'll come back into the conversations, but I did want to talk a little bit more about just this concept of how we handle our everyday decisions and a more significant one. So, ma'am, if you would, tell me about an event in your life and how you handled it that you think was a a real focus of your efforts on making sure you were certain about what you did before you did it?
B29, an event like anything?
Yeah, dealing with children, dealing with moving, dealing with career changes, anything like that. Just something to the extent that you have.
I just moved from Chicago. I've been
Okay.
living there all my life. So it was very, very hard for me to come from a city and live the city life and come here to Florida. But I had to make that choice for my kids because I wanted my kids to have a better life. And for the older kids, it was hard for them because they also love the city. But for the smaller kids, we did it, and we did it as a family. So that was the hardest thing I had to do. I left most of my family. I'm just here with my kids and my husband. But it's something you got to do when you got to better your life.
Was that something that you thought through, obviously, before deciding it? Weighed the possibilities?
Yes, jobs, financial, physical. I mean, it's hot here. We got different temperature in Chicago. I thought about it a lot.
Can you give the same attention to the detail and to the considerations in this case as you gave to a decision like
Yes.
that? Any concern with being able to do that?
No.
Mr. Del Rionda talked about assumptions that we make and how they have no place here. I want to talk to you about that for just a moment. Do you think we make assumptions every day?
Every day.
Give me an example of maybe 2 or 3 assumptions you made since you got up this morning till you got here.
I thought it was going to be a short day.
You're still working? That was completely, that was...
Another assumption, the air conditioner was going to be down.
Well, down, you got it.
Yeah.
It's down.
It still
The
feels
temperature
cold.
is down. You asked for the wrong thing. That's what you get for dissing me. So you make these assumptions as you move through your life. I made an assumption today that everyone was going to stay in their lane as I was driving, right? I mean, they may not, but you sort of presume things are going to go as they go.
Yes.
Would you agree?
Yes.
And I think what Mr. Del Rionda was suggesting was that we need to be careful that assumptions that we live our lives by on the outside don't infect what we do here today.
Don't conflict.
Do you understand my concern with that?
Yes.
Why do you think I'm concerned? Why are we talking about this now? Why do I care enough to ask you this question?
I think a lot of us use our own situations or our own past judgment because everybody says they don't judge, but there's always one time that you're wrong. And everybody uses what you've gone through in life or and they for some reason either add or put more to the situation that you're going through now.
You bring your life experiences,
Exactly.
correct? Mr. Del Rionda also said, and he talked about our God-given common sense. And I think I'm going to disagree with him a little bit there as well. I don't think God gives us common sense. I think God gives us a mind, and he gives us his teachings from which we can learn some common sense. But I think we get common sense from our life experiences. Do you agree with that?
I agree.
Do you think that a 65-year-old has more common sense than a 5-year-old?
Of course.
Right? Because we learn
Yes, you
from doing. My common sense was I now know not to walk into the street without looking. I got that from my mom. I can hear her voice reminding me of that wherever she was. You can just hear it, right? And those are life experiences. And when we tell you that we want you to maintain your God-given or your life-given common sense, we really mean that. We don't expect you to become robots in this courtroom. But we need to be real careful that those life experiences that gave you the common sense don't follow you in so much so that they're going to affect your verdict. Any concern with that?
No.
In the back, sir? This concept of common sense and where to fit that in to what we are asking you to do here today. What do you think about that?
J81, the common sense that we have, like you said, the life experiences that we've had, we can't let them affect what we hear. We have to base everything off the evidence. So I agree with that.
Any concern or how will you agree to be cautious about, though we use our life experiences to give us common sense, to be cautious about individual life experiences deciding how you decide a verdict here?
Yes, I agree with that, to be cautious. The fact that no matter what we've gone through, we still have to base this case on, the jury has to base their verdict off the evidence that's presented.
Do you think this is a unique process? What we're doing here and what we're about to do for the next couple of weeks? Well, tell me your thoughts on this process so far.
I think this is just really an expanded version of what we go through in criminal courts in this country every day, making sure that we get an impartial jury, because no matter if it's this case or any other case, both sides want to make sure that the jury is impartial, that they're only going to make a decision, reach a decision based off the evidence that's presented.
Okay. I guess my question is, do you think just the concept of a criminal trial itself is sort of a unique undertaking?
No.
Okay. Now, what do you think about that? This idea that we have you sitting here in a courtroom, giving you these standards that you never applied before unless you sat as a criminal jury before. Do you think that's somewhat unique? And I'm talking about the one in the second row.
On B61?
Yes.
No, I don't think that's unique. Not that I have experience in the past, but I think it's helpful for the jury to understand what the rules are and what we are expected to do as jurors.
Okay.
And I think going through it definitely helps, and I think these conversations we're having will definitely help the jury.
Good. So you disagree with her when she said that, what she said earlier? About
What did
she thought this would be a quick day, an early day? The fact that this is actually working out okay?
I think she was just more hopeful.
All right. Ma'am, I think again, you nodded, so now I'm going to speak to you. Would you acknowledge that this is sort of a unique experience that we're asking you to join us in here in a criminal courtroom?
B76. Yeah, I think it's a great opportunity. And I think if one of my family members was on either side, I would want this process to happen to make sure that they got a fair trial.
Here's a concern, and I want to see how you think about it. I think this is a very unique experience for people on that side of this podium, because we're bringing you into our world where we've lived and asking you to apply rules you don't normally apply, to listen to evidence in ways you don't normally listen to evidence, and then to wait until the end before making a decision, and to apply instructions that, though you'll have a copy of it, you've never heard before. So I'm concerned that you're going to be able to do that. Put me at ease. How are you going to address the uniqueness of this situation and apply everything properly?
Follow the instructions, listen to all the evidence, and then wait until the end to make my final decision.
Because I'm concerned, as I mentioned earlier, with the apples and the oranges, that you will default to what you're used to. You'll default to the assumptions that we make every day when you get up and believe that people are going to drive the way they're supposed to, or that your job's going to be open when you walk in the door. So I guess my concern is to make sure that you stay vigilant that this is a somewhat unique process and not fall into what you do outside the courtroom.
Absolutely, I would focus 100% and follow exactly the rules.
Thank you. Ma'am, what do you think about that concern that I just addressed? That, first of all, do you agree with me that this is sort of a unique setting that we're asking you to join us in.
It is unique, and E22, and I can understand your concerns. It's difficult to stand outside of yourself from the things that you're accustomed to doing and the things you're accustomed to believing in your daily life. But I think part of the process is that there will be a group of individuals, and if one person should then, by default, fall back on their generalizations or what have you, then the rest of the group is also there. There's that dynamic in place to kind of corral, bring them back.
And if you sit on the
topic.
I'm sorry. And if you sit on the jury, will you assure us and the rest of the jury that you will assist in keeping the jury on track and not falling back to those outside default mechanisms? Any concern with that? Do you understand my concern with making sure that it happens the right way? Okay. Now, what do you think? Yes, sir.
B7, I do have a little bit of concern when you mentioned bringing us into your world.
Sure.
I know that there has been a concept before of a professional jury.
Yes.
And that has been decided that, no, we don't want professional juries. We
Right.
want to bring people
Sure.
from the outside. So wouldn't, if it was that important that, to come into your world, wouldn't the professional jury be a better option?
Great conversation. I don't know that the court would allow me to go into it too far with you right now because it's not a good part of jury selection, but professional juries would just be in our system all the time. We need jurors from the real world. I'm not saying we're faking here, but the real world, because it is in fact a jury of Mr. Zimmerman's peers. It is those people who walk their daily life just as he does, and we bring you here. My concern is this. My concern is we've done this. We're going to have opening statements. There's going to be evidence presented in a way that unless you've sat in a trial, you've never seen it happen that way before. Only one lawyer asks, then only the other lawyer asks, and then another witness, and another. And you don't get to do much but listen and wait and listen and see more evidence. And then at the very end, we'll tell you what to do and ask you to go do it. And I think that that's foreign to the way we run our daily lives. I doubt you do that in business. I doubt you do that in your social relationships. I doubt you do that anywhere else but in a courtroom. And I just want to make certain that you can take that on. Do you see what I'm saying?
Okay.
Ma'am, what do you think about that? Well, you shook your head.
I was rocked. B29. No, I really believe that I don't question anything you guys are saying, because I'm pretty sure you guys do this every day, and exactly where I'm from, the outside world. I mean, I'm not saying you guys, different worlds. We all live in the same world, but you're accustomed to do, this is your job, this is what you guys, and we're not. But I feel that to give a person a fair trial and to get them the jurors that you need, you have to see both sides. Not only his, not only the other person, but also the jury, because we all live in the outside world. So we all know what's outside. We all, work 40 hours a week. We take care of our kids. Everybody has their own, situations. But at the end of the day, you can't. What you're trying to say is that just don't bring your problems and bring what you've learned and how you dealt with it into this trial or case or situation, right?
Yes, ma'am.
In reference to your concern,
Yes.
I think we all have some way that we can apply the same way of thinking of where we all have something, whether it be your daily job or your house, that you have rules that you have to follow, that you're responsible for holding yourself accountable, as well as sometimes others as well.
Your number?
B61. And I guess the way I think of it is in my line of work, safety is really important. So I have to hold myself accountable to being safe and working safe, as well as my peers and making sure that they're accountable and they're being safe, and I'm accountable for them as well. So I think whatever jury comes together, that's a responsibility you have. you have to hold yourself accountable for these rules, and at the same time, each other, and talk about it when maybe that's not happening, or you know, expanding on more.
Thank you. Because that's the concern, that's my concern, is that you default to something else and not be vigilant. Now, what do you think about what she just said and how that's going to apply to a jury? Behind you, I'm letting you go now.
I'm
Yes.
75. I agree with both what they said. I also, in previous employments, have had to hold people accountable for what they do and for what I do as well. And we all need that reminder, like, oh, wait a minute, you're supposed to do this. Because in all, our common sense is based off of our experiences. And if we don't bring our experiences into it, then it's a little bit harder to make a decision. So you have to pick the experiences that won't be biased or based on one thing or another.
Thank you again, appreciate it. I will move on unless someone else has any other comments or questions about that. Yes, ma'am.
I guess I would kind of liken it to conducting like a scientific experiment, although this is not an experiment, but you can have a hypothesis, but you conduct your experiment and you can't let your hypothesis, you can't bring your bias in because then the experiment is tainted and you can't rely on the results. So you just look at the facts and the data and you make your conclusion. Because you know we do all have our biases or whatever, but you just set it aside.
Agreed.
Oh, I'm sorry. Yes.
Yeah, because what happens if you believe your hypothesis before you test it?
Then you may not get the proper conclusion.
You actually have some bias then, don't you?
Well,
You believe it should be true already.
Right.
Okay.
So, yeah.
Dangerous concept in trying to test hypotheses, would you agree?
Yes.
Okay.
Yeah, you just leave that. It has no bearing on your results.
Mm-hmm. Let's talk about bias for a minute, since you mentioned it. Mr. De La Rionda said that bias has no place in this trial, and I think everyone agrees with that, right? Let's go some group agreement. Does everyone agree that bias doesn't have any place in the trial? Yes. Okay. What about witness bias? We just said that bias doesn't have any place in the trial. What about witness bias? So what do you think about, how about the fact that a witness may be biased?
Same thing. I just want to hear what he's got to say, and then.
Okay. The judge will tell you that, I think the bias that the prosecution was talking about was that we don't want you coming in with any bias, right? But the judge is going to tell you about bias in the courtroom and tell you that you might consider it. First of all, again, just to make sure we're in agreement, any problem with following the rules that the judge gives you as far as how to look at this evidence? We're all agreeing to that, right?
Right. Yes.
Okay, she's going to tell you that when you watch witnesses, she's going to ask or instruct you that you may want to consider what they bring to the courtroom. She'll say to you, it's up to you to decide what evidence is reliable. You know, we're going to talk about opinions in a minute, but you get to decide what's reliable. It's your opinion as to what's reliable. So the concept that opinions don't come up in a courtroom, we're going to talk about that in a minute, but you are the people who will have the opinions. Because you will have the opinion as to whether or not each individual piece of evidence is reliable. And the judge will say, it's up to you to decide what's reliable. You should use your common sense. We've talked about that in deciding what is the best evidence and which evidence should not be relied upon considering your verdict. She'll tell you that you may find some of the evidence not reliable. Look at it and go, I don't get it. There's a conflict. I just don't believe they have the basis for it. We have the opinion as an individual juror, and hopefully you'll discuss it with the rest of the jury, that it's not reliable. Or just less reliable than other evidence. Anyone have a concern that you're going to be given that charge, that instruction, and in effect that opportunity. Any concerns with that? You should consider how the witness acted, as well as what they said, and some of the things you should consider. And the judge will tell you, these are things you should consider. Did the witness seem to have an opportunity to see and understand things that they're testifying about? Of course, you'll look at that and you'll say, wait a minute, he said he saw stuff I don't think he could have seen. That is what the judge will tell you to consider and to give your opinions on it. Did the witness seem to have an accurate memory? And if not, why not? And you'll be able to consider that. Was the witness honest and straightforward? This is why we want somebody besides some professional jury. Because we want 6 of you to come in with your life experiences and your common sense and say, I gotta look and see if this person is being straightforward in answering questions. And here's a very specific point. Did the witness have some interest in how the case should be decided? Did they have an interest in it? Well, that may affect their presentation to you, and you have to consider that as far as a potential bias. We know who has interest in this case, right? You'll have to consider that, and you'll have to sort of vet that through and say, not that they're lying, perjuring themselves, but that you have to look at their evidence in a way that may consider their bias. Does anyone have a problem with taking that on? Ma'am, at the end, what do you think about that? Now that we're talking about you're going to be told to make these decisions, to have these opinions about witnesses. Do you have any problem doing that?
G66. No, I don't. You have to take into consideration what he's saying, even how he's acting on the stand. I don't think
Okay. Ma'am, in the front row, what do you think about now what we're talking about with this witness bias?
I am sure that we will see bias in some of the witnesses, and hopefully we'll be able to determine, based on the questioning from both sides, which way we feel that particular issue needs to be handled.
Sure.
That's your E73?
Yes.
Okay. Ma'am, what do you think about what we've now been talking about right up front with the yellow?
B51, I gave no consideration to biases other than that I didn't want my biases to be influencing any decision. I wasn't aware until you just defined it for us that those are considerations for us. I've never had such a dissection of our role as I have this morning. I appreciate it. It's sometimes a little confusing and concerning, but it's helpful for what you've done. So I didn't think to the biases of a witness. That's a natural reaction that we would have. So the fact that we are going to be allowed to consider it, it's good to know that, because I didn't know that.
Okay. I don't think this is hugely different than the real world. I
No.
think that you do this every day, don't you?
Absolutely.
We just sort of make sure that we put them in a list,
Yes.
because we're lawyers.
True.
And that you should consider. We'll tell you stuff you shouldn't consider because they're not in here. But don't you think that you make in your general life and world outside that you do this immediately? Whenever you see anybody, anywhere?
Sure.
Right? I mean, as soon as I walked in, first time you saw me, something came to mind, right?
Sure.
Ties too loud or whatever it might be. We do that, don't we?
Sure.
And that's our human experience, as we talked about earlier.
Absolutely.
We're not asking you to leave that type of common sense out. But I want to make sure that we talk about it.
Yes.
Because what would really be bad is if we didn't have these conversations, if for example, the first time you heard about witness bias was some quick instruction the judge gave you and you were like, someone said not to consider bias. What do I do?
Right.
I think she said consider it. I think he said don't. And that confusion is dangerous.
I agree.
Would you agree?
I agree.
Ma'am, next to her, what do you think about this idea of witness bias and just the concept that you're going to be asked as a juror to look at these issues?
B86. You're basically asking us to use our common sense to decide if the stuff is relevant that we're going to be listening to.
Within this context, sure. Any problem being able to do that?
No.
Okay. Do you think that we walk through life every day with certain suppositions or ideas that we think about people around us?
Yes. I believe some people have more common sense than others, though.
Okay.
I deal with people that are geniuses that have no common sense.
Give me some examples of how that shows up in your life. Not that, but sort of the biases, not even the biases, just the presumptions that you make as you wander through life. But just what do you do? Go ahead.
People that have less common sense, I have to help them more.
Okay. So somebody may say just one thing and you presume, great, going to deal with it this way?
Correct.
You could be wrong, right? You could be.
I could be.
But you look at a situation and you react to it as best you can under those existing circumstances, right?
Yes.
Does anyone have when I'm talking to her, I don't want to presume that it's accurate because I'm saying it or she's agreeing or she's saying it. So in the back, what do you think about this little concept of we walk through our lives making these minuscule or immediate decisions all the time?
87, sir. I agree that if we do that, my analogy it had in my mind when y'all were talking about that was car salesman. If I go to the Ford dealer, they're going to tell me all the good things about their dealer, and I'm going to have to weigh, their biases in that, or some other dealership, and figure out what's right, what's true, or what's not true.
Do you agree that we sort of make these immediate decisions or suppositions about people and things every day of our lives?
I would think that's a true statement. I know I do even at home with my wife, so yes.
Sure. And you would agree that you may be wrong when you make that supposition, correct?
Distinct possibility, yes, sir.
But that until you're proven wrong, you're going to act on it, aren't you?
Or I may dig into it, but.
Okay. We also had talked a bit, or it was talked a bit, about sympathy having no role. So we haven't talked enough yet, so I'm going to pick on you, the one in the center row. What do you think about this concept that we tell you that sympathy should not play a role in your verdict?
I think that's a fair statement. Me and my value judgments, my personal experiences, I've always taken a stoic approach. I said before, my personal word diary, I'm not sure how you say it, that, and people may disagree, people may not, but I feel that emotions should not be taken into consideration when you're making a decision. I said before, I think emotions are weak in that regard. So sympathy, anger, anything like that, throw it out the window when it comes to a decision like that.
I remember you saying that, which is why.
Excuse me, that's Jeremy 72.
Thank you, Your Honor.
72.
And that's why I picked on you, because I remember you saying that the other day. And I wanted to follow up with, well, isn't sympathy a human emotion?
It is.
So how do you dissect away a human emotion? How are you going to do that?
What do you mean?
Well, it's a human emotion. It's pretty normal, isn't it, for us to feel sympathy for the loss of another?
I disagree with that to some extent. Again, me and my personal experiences, I've never had very close relationships. So where one person may feel sympathetic, I generally feel different.
Okay. All right. I'm going to ask her a question up front, if you would. Your number?
B76.
Do you think that sympathy is a normal human emotion?
Yes.
Tell me about that.
I think it's a natural instinct to have sympathy.
Sure.
But sometimes you have to make decisions where you have to eliminate that so that you make a analytical decision.
That's why I said this is a unique world that we live in. Because you wouldn't intentionally ignore sympathy in most of your daily life, would you?
No.
Yet we're going to ask you to do it here.
Yes.
How are you going to accomplish that?
I've had to do that with my own life, with tenants that I've had to make decisions that would affect my livelihood. So I put the emotions to the side and I base it on the end result of what I want to accomplish.
So you sit on this jury here today, and the judge will tell you exactly that sympathy is not an appropriate consideration. Will you be able to listen to the judge and apply that?
Absolutely.
Okay. So what do you think about this concept of sympathy being, would you agree it's a pretty normal human emotion?
Yes, a B35, yes, I really do. But I think it's an emotion like any other emotion. We have to be able to control that, put it aside, to be able to come to the end result. Like if you got something against someone you really don't care for, but you're invited to, say, a person's friend's house, and that person's a person's friend, and the other person's friend you got invited to, and they're there. You have to be able to put that aside to be able to get along with what is going on inside the house. I think that would apply in this case.
Any concern with being able to apply that?
No, sir.
Understand my concern in making sure we talk about it so that it doesn't creep its way in?
Yes, sir.
Are you okay with us asking you, and I'm going to say it in a bad way. Any concern with us asking you to be less human than you're used to being in your life, to be a juror with us?
Well, this instant, no, because I understand what the end results are all about.
Okay. Ma'am, what do you think about that?
I agree. I mean, that's where the evidence and all the stuff you guys are going to do comes into play. Oh, sorry. And sympathy, emotion really doesn't play a part in any of the trial. And you just have to learn somehow, not really learn, but adjust to the situation at the time. Because you don't know what's going to come up. We have no idea what's going to happen.
Ma'am, right there in the black?
Yes.
Your number?
K80.
And what do you think about this? This concept of sympathy and how to excise it out from your decision-making process for this trial?
I think sympathy is a very human emotion. I think humans by nature are very emotional. I think certain humans are more emotional than others. I think that's just the nature and the makeup of each one of us, and we're all different. I think when it pertains to this trial, I think everyone, and you would hope, especially those all sitting in this jury box, can rise above themselves and look at the bigger picture of this is something bigger than all of us, and that needs to be put aside. And you would hope that somebody's character and integrity would rise to the top.
And will you then agree that should it show up in the jury deliberations that you're involved in, that you will talk about it and make sure that it does not become part of your considerations?
Yes, I think it's very important to keep the facts of the matter on the forefront.
Mr. Del Leonte talked about taking the law into your own hands and whether or not that was appropriate. And I think everyone said it wasn't. Is that correct? That's to the whole group.
Yes.
It's not appropriate to take the law into your own hands, right? Okay. Ever? You know what a Good Samaritan law is? What's that?
B76. That you help a person if they're in need. Like if I saw, someone beating a child, I would definitely get involved and
Grab the child away.
Absolutely, yeah.
Push the person down if you needed to, and protect the child.
Yes.
Is that taking the law into your own hands?
Yeah.
It is, isn't it? Is it okay?
And I think so.
Sometimes.
So sometimes the law, it's okay to take the law into your own hands. Let's talk about when. You had something, sir?
I-24.
Sir in the back?
Age 18, I said at that point, yeah, it is justified. I mean, there's a kid being in danger, it is justified at that point, yeah.
So the circumstances may justify you acting in a way that you otherwise wouldn't. Is that correct? Okay. And your number in the back?
Age 18.
Okay. Any other, ma'am, yes?
K95, I believe that there's a lot of bystander effect going on where people see things happening and they don't get involved because they don't want to be involved. And I would think that if somebody was harmed or an accident, that taking your law in your own hands, not necessarily taking your law, but it's just being a good Samaritan and helping that person and assisting them until the EMT or somebody got there.
Would you agree that there are times when a decision has to be made between alternatives and you just have to make that decision?
Yes.
And sometimes that means, in effect, taking the law into your own hands?
Yes.
Okay, let's talk about self-defense. Is that taking the law in your own hands?
Self-defense?
Sure.
No, I believe it's a K95. Self-defense is when somebody is coming at you or you at yourself or your children. And I'll give you an example. I was walking my daughter, she on a bike, and a dog came out and went to bite her, and I stepped in the middle, so the dog bit me instead of her.
Right.
So to me, that is taking, self-defense in the sense that I was protecting my daughter by taking the dog bite.
Okay, and there's a concept in the law called protecting others, that you're allowed to act in a way when you're coming to the aid of another person, and that's under the law justified under certain circumstances. Is that what you're talking about?
Yes, sir.
So that, in effect, aren't you making a decision at that point to, in effect, take the law into your own hands by acting a certain way?
Yes, I guess, yes, sir.
Okay. Ma'am, what do you think about that in the second row?
G29. I think that when you feel that your life or a minor's life is in danger, I think it's totally like you kind of just react to it. It's not like it's a decision that you have to like weigh on. Like it's like a split-second type of reaction, and I think everybody is entitled to do that in order to protect their life.
So is what you're saying is if there's sufficient reason to take the law into your own hands, you're allowed to?
I think so, yes.
Okay. Who disagrees with that? Come on. Who disagrees with that? Who thinks under no circumstances do you ever get to take the law into your own hands under any circumstances? I'll come to you. Go ahead.
I think there is a difference between taking the law into your own hands and protecting yourself. I think taking the law into your own hands is more of a, something you would do, proactively instead of reactively.
Great. And before I get to you, and I will, it was a little bit of a trick question. Because acting in self-defense isn't really taking the law into your own hands, it's acting within the confines of the law of self-defense, isn't it?
Right, just like the Good Samaritan.
Sure. That's not taking the law into your own hands, right?
It's following the law.
Would you agree that, go ahead.
E54, that's what I was going to say. It depends on what laws you're talking about.
Right. So when someone says it's against the law to take the law into your own hands, it presumes you're doing something illegal, doesn't it? Right?
Well, it presumes that you're doing something within this, there's a law that you're protecting, but yet you necessarily don't have the authority to do that.
Exactly. And I think, I'm presuming that's what Mr. Delorionda meant when he said it's not appropriate to take the law into your own hands. And you all just said, yeah, of course that makes sense, right? But to the extent that the law allows for you to react, then that's not really taking the law into your own hands, it's simply using the law that exists to your benefit. Would you agree?
Yeah, you're following the law in those cases.
Okay, and I think it was you who had your hand raised.
Page 86, you took the words out of my mouth. I was going to comment on the phrase, taking the law into your own hands is
kind of deciding what the law should be rather than following the law that's already in place, such as self-defense.
Okay.
There's already limitations and rules on that that you're able to follow.
Let's talk about that for a minute. Self-defense. Yes, sir.
I'm going to say that.
Your number?
H81. I think what some of the jurors are describing is that you've got this instinctive reaction to protect. It's a human reaction. Nobody really thinks about in that moment, what's the law? If you're reacting to protect a child or your family, that's just a natural human reaction. So this concept of taking the law into your own hands, it's outside of that moment.
I guess you include with that protecting a child or your family or yourself?
Or yourself.
Okay. And yeah, you can't go outside the law. But within the law, if you have the right to protect yourself, would you agree with that?
Yeah, so my point was that if it's a human reaction to protect, whether it's yourself, your family, child, in that moment, that's a human reaction, a defensive reaction. That's different than proactively acting in the context of taking the law into your own hands.
Okay. Ma'am, in the front with the, yes, your number?
Oh, me?
Yes.
E40.
What do you think about what he just said?
I think I just got a little more confused.
Okay. What he said, I think, was that in the heat of the moment of making a decision to protect yourself or your loved ones or a child, that it's just a normal human reaction to protect oneself. And you don't think about it much. It's just how we're hardwired. Is that sort of what you were saying?
Yeah.
What do you think about that?
I can agree with that. I think we have spontaneity in responding to situations. For example, to put out a fire or to do something, you act in the moment for the betterment of yourself or others or the people around you or the situation, and then you can take the step back and say, oh my gosh, I can't believe I just did that. You have that pause. So I do agree with that piece that he said, yes.
And I think what you're talking about is when you see a child run out into the street, do you wait until you see if it's your child or just get them out? Is that?
It's instinctive. You react to it. You don't think about, is this within the context of the law or not? You're going to go react to protect.
Okay. Right. And so with the red shirt, I know that I didn't get back to you early when I said I would, so did you have a comment to talk about?
Well, actually, it's what you said about G63. When a juror over there, I don't know which one, said something with the Good Samaritan law actually being a law that allows you to take actions that would otherwise be unlawful without the Good Samaritan law. So, and yet someone might make a decision, like in the heat of the moment, make a decision to do something for the safety of others, let's say, not even having knowledge of the Good Samaritan law. So they might even, as far as they know, be disregarding the law to do that.
Okay. And that sort of brings us to, yes, ma'am.
Oh, I'm sorry, I just wanted to clarify. Are we agreeing that the phrase taking the law into your own hands means more of a negative impact, or of just like someone did wrong, they stole, I'm going to punish them my own way? Or is that what we're agreeing to? Because
Did you remember? Okay.
Because I, at least my job, I execute the law.
Right.
I do employment law. I do take the law in my own hands because my decision will possibly terminate the employee.
You apply the law.
Right, I apply the law.
I think what we're saying, and I don't want to speak for the group, but I want to have the conversation that if the concept of taking the law into your own hands is equivalent to doing something illegal, then we sort of agree we're not supposed to do that. Does that make sense? Is that what we're talking about? But that taking the law into your own hands does not suggest that utilizing defense of others, grabbing a child, which might be a battery under some scenario, and getting them out of traffic, is that taking the law into your own hands? That's the human nature that we have towards self-preservation and those of others. That's sort of what we're talking about. And then we were going to lead into self-defense. And the law, not outside the law, but the law of self-defense. So let's talk about that for a minute, because I just want to get your feelings on whether or not you could apply this and your concerns about it. An issue in this case is whether or not Mr. Zimmerman acted in self-defense. And here's a instruction you're going to get. The use of deadly force is justifiable only if the defendant reasonably believes the force is necessary to prevent imminent death or great bodily harm to, I'm going to say himself, as alternatives. But let's talk about that for a minute. The use of deadly force, it'll be described as basically force that could cause death, is justifiable. It's within the law, as we talked about, if Mr. Zimmerman reasonably believes that that force is necessary to prevent great bodily injury. It includes preventing death, but if you think about it, if you think what you're doing is preventing great bodily injury, then that you're allowed to resist that with deadly force. So, what do you think about that law? Ma'am, yes.
E40. I think there are pieces within that through a trial process needs to be gleaned out as to the presumption. There was a phrase you used there, if that person thought that there was going to be harm to them, if they were in imminent danger.
Reasonably believed.
Thank you,
imminent
reasonably
danger.
believed. I think that's going to be information that needs to be fleshed out to get to and hear through what that might mean.
Okay.
To set the stage, then to gauge the rest of that sentence, I believe.
Great. Where are you going to get that from?
Through the trial process, through the witnesses, through the evidence, direct or indirect, that will be presented, through the lines of questioning, through diagrams, whatever will be presented in the confines of the court.
You're getting it from anywhere else?
No.
But the law and the testimony and the evidence.
And then the judge's instructions.
Right. And I'll get to you in a second. And who carries that burden?
I'm sorry?
And who carries that burden?
To put all that together, the jurors.
Who carries the burden to show it to you?
Oh, I'm sorry, the state of Florida.
You had a comment, ma'am?
E6, does the law provide any clarification on, what is reasonable? One person may, I'm wondering if it provides any clarification on that.
I'll read it to you.
Okay.
It's going to give you some, and sort of like other instructions, we talked about defining abiding. We're not going to define abiding. We're not going to define every word. I'm going to read to you what the judge will, and then we'll talk about that, okay? In deciding whether the defendant was justified, which is what we're talking about, in the use of deadly force, you must judge him by the circumstances in which he was surrounded at the time the force was used. So, is it a right-on definition? No. But what it tells you is you have to look at it through...
I'm objective to paraphrasing part of the instruction.
If you want me to read
I'll read the whole thing. Oh, sorry.
No, I would prefer to be the one who reads any instructions
Yes,
to the
ma'am.
jury, not any counsel. So if either side wants me to read the entire instruction to the prospective jurors, I would be happy to
May
do
I
so.
approach? I have it.
Yes.
Sorry for the underlining.
I'm going to read the entire instruction.
Yes, ma'am.
Okay, ladies and gentlemen, with the understanding that if you are jurors that are selected to sit in this case, at the end of the trial, I will be giving you instructions that you are to follow on the law and to apply the facts as you find them to the law that I will instruct. Right now, I'm going to give you an instruction to give you an idea. Please keep in mind that portions of this instruction may or may not change slightly after all of the evidence in the case is closed. And it reads as follows: justifiable use of deadly force. An issue in this case is whether the defendant acted in self-defense. It is a defense to the offense with which George Zimmerman is charged if the death of Trayvon Martin resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent 1, imminent death or great bodily harm to himself or another, or 2, the imminent commission of aggravated battery against himself or another. Aggravated battery is intentionally touching or striking another against his or her will, and in committing the battery, intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to the other person. In deciding whether the defendant was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that danger could be avoided only through the use of that force. Based upon the appearances, the defendant must have actually believed that the danger was real. If the defendant was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent the death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of the defendant and Trayvon Martin. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether the defendant was justified in the use of deadly force, you should find the defendant not guilty. However, if from the evidence you are convinced that the defendant was not justified in the use of deadly force, you should find him guilty if all of the elements of the charge have been proved.
If I might retrieve that, Yvonne, just so I don't use the line on.
Yes.
Thank you. That is what you're going to hear again and have with you concerning the issue. So with that thought in mind, do you have any questions about how you're going to apply that law?
Well, that does clarify it a bit, that any person, you would compare it to another person, and would they make the same decision in that?
A reasonable person, is that what you're speaking?
Right.
Yes, under the circumstances.
Because I guess I was wondering, well, people have different, some people may be more paranoid or anxious than another.
Mm-hmm.
So I was wondering how, for them it may be reasonable, but for another it might not be.
Okay.
But, so for any reasonable person, that's kind of the standard.
We are now.
Answer
No,
that
I wasn't
question.
going to. I was going to say I can't.
Because that's in the province of the jury. When you're back there deliberating, those are the types of things that you discuss and you come together with.
Okay.
We can't tell you how to do that.
Oh.
My precise answer was going to be, that's exactly why we have 6 of you who have to listen to the evidence, listen to the law, apply these instructions as best you can. Use your common sense we've talked about, but to try and give you more than what this says. We've thought about this a lot. This has been around for a long, long time. these are the instructions. Commenting much more on it and saying, well, maybe this word could mean that is what we're absolutely not supposed to do. It's why we have you. Do you understand that?
Yes. Yeah, I was E6 if,
Yes.
okay.
Ma'am in the back with the green on, but yeah, don't shoot, yes. What do you think about this concept now of what we call, the catchphrase is self-defense, but the statute is justifiable use of deadly force? What do you think about that as a concept?
Well, what I think is that, and what has become more clear to me throughout the couple of days is that there is a law that the state of Florida has to prove beyond a burden, beyond a, the burden of proof is on them to prove beyond a reasonable doubt.
Yes.
And that it is our responsibility as the jurors to apply what we believe that law to mean according to the facts that we have been presented. And there is now a law that she has just read that is the defense, and it is our responsibility to apply what we understand that defense to mean according to the law, and then make a decision which of those apply in this case.
Absolutely.
That was Juror D14. I'm sorry.
Now, one thing one thing Judge Nelson read to you was that in the right circumstances, somebody under this has no duty to retreat before using deadly force. That also has sort of a shorthand name called stand your ground. So let me pick on someone else who I haven't spoken to in a while. Sir in the blue shirt back there, you escaped my view for a couple hours here. What the judge read to you said, in part, I don't want to just focus on it too much except to say that a defendant not engaged in unlawful activity, attacked in a place where he had the right to be, has no duty to retreat and may stand his ground. That is the concept of stand your ground in this state. What are your thoughts about that?
H6. I never really put much thought to the law itself. I mean, I believe it was put there for a reason because people felt they might have the necessity to protect themselves in the event of a situation would arise where they need to.
Okay, it sounds like traditional self-defense, right?
Yeah, and I feel that, I mean, if you're somewhere you're supposed to be, you're allowed to be, and you get attacked, that you should be able to defend yourself.
Without having to retreat.
Right.
And do you agree with that?
I do agree.
Who has concerns with that? Who has concerns with the concept that though you have the right to defend yourself, we have a law in this state that says you have no duty to retreat, to back out of the circumstance before you do? One person out of 40, 2, 3, 4, 5, 6. Who had 6 people have concerns with that? Okay, tell me about your concern.
B7. I remember when I just want to let you know that when this law was originally proposed, or this, I guess, amendment to the law.
Yes.
I was opposed to it.
Okay.
I still am.
You still are opposed to the fact that it was an extension. Well, let's back up a little bit and we'll come to that. Do you know what the castle doctrine is, traditionally known as? What's your understanding?
That would be stand your ground within your home.
Sure. Anyone have a problem with the castle doctrine, which is this real generic overview? You can protect yourself in your home. Okay. Do you understand with your opposition to this law when it first passed that basically extends the castle doctrine outside the home?
Yes, I understand.
Is that your understanding of it?
The purpose.
Does anybody have a different understanding of that? that it takes the castle doctrine and moves it outside of the home, into your neighborhood, for example? Anyone have a different understanding of that new law? Yes?
B76, I'm not sure that I understand the retreat part.
Okay. You don't have, under this law, and I want to see if you can agree with it, because we may ask you to apply it. That are the
Can counsel please approach?
there's this distinction between wanting to answer some questions when they come up and the fact that we need to rely on the instructions, because they really, I don't mean me personally, but we as a profession has put a lot of work into making sure that this is, and to the extent that words are in there, that's why the 6 of you will talk about it, and then you'll sort of decide on it. So me sitting here saying retreat is my, it would be nothing but opinion, and I'm not supposed to give that, and it would confuse you, and worse than that, it might even confuse the law. So, and I want to make sure that in theory, that a law that exists in this state.
Okay, I'm going to interject again to the word theory. Ladies and gentlemen, if you are selected to sit as a jury on this case, you will be instructed as to the law that applies to this case. And you are to apply the facts as you find them. You would be the finder of the facts. The court gives you the law. Those two roles do not overlap. So the question is, given the law that you will be read, and a copy of which will go back with you to the jury room, will you be able to follow that law? Is there anybody here who would not be able to do so? Yes, sir, B7.
May I inquire?
Yes, you may.
Thank you. So, what we just read to you, I'm sorry, what Judge Nelson just read to you is the law in Florida. And to be a good juror in this case, even if you disagree with some of the laws, you must agree to apply them. You could, for example, a law could be that you can't wear blue shirts in this state, as arbitrary as that might be. If you were sitting on a jury and there was conclusive evidence that the defendant was wearing a blue shirt, though you disagree with the law, you would have to apply it. And of course, there are more subtleties to all of that. But so my question to you today is, even though you disagree with a law that says you have no duty to retreat, that if you sat in the jury and that is the law, would you be able to apply the facts that you hear to that law and come up with a lawful verdict? So, and that's a question to everyone, but so I ask you that if the judge instructs you on the law, even though you disagree with it, can you still agree to apply it?
I have a hard time answering that.
Okay, now is the time. Like we talked about, there's no absolute right answer or something.
You know, it's up to the jury.
I'm sorry?
It's up to the jury.
Right. The 6 of you, or you to sit on it to make the decision to apply it. The question is, and I want to be careful about, or certain about this, that if you disagree with the law such that it would infect your ability to be a fair juror, we won't ask you to do that. If you disagree with the law, but can set aside that disagreement in favor of the law the judge gives you, then you consider the jury. Which do you think it is?
I would hope that I could follow the law.
The other part that the court read to you, I want to spend a moment on. So, self-defense becomes an issue in the case, and the evidence is out there, and you have to consider it. Let me ask you this question. It's a slightly trick question, but I'm going to ask it in a way that tries to get a response. Ma'am, in the middle? Yes. Your number? G29. You go back and deliberate, and you have a doubt, a reasonable doubt, as to whether Mr. Zimmerman proved he was acting in self-defense. What do you do?
Is it really like it's not his burden to prove it, right? It's the state's?
That was a partially trick question.
Okay. If I had doubt, then I would have to make that decision that he's not guilty.
That he's what?
That he's not guilty. Like if I had doubt whether or not he did, if it was in fact self-defense or not.
Does anyone disagree with what she just said? Sure.
69. Can you say your question again?
Sure. Let's say that you have a reasonable doubt as to whether Mr. Zimmerman acted in self-defense. I sort of said he proved self-defense, and she caught me by saying, Mr. Zimmerman, any criminal defendant, has absolutely nothing to prove. It's all on the state. So if, in fact, you had a reasonable doubt as to whether or not the state disproved self-defense, reasonable doubt as to whether or not the state disproved self-defense, what would you do?
If the state did not prove that it was self-defense.
If they didn't, I know it's like trying to prove a negative. That's why I'm saying it a couple of times.
Why
If they do
would the
not,
state not prove that it's self-defense if they're trying to prosecute him?
well, they have to disprove that it was self-defense.
Projecting opinions as opposed to reading the instruction or the law.
That is the law, Your Honor.
I can read the instruction again if you wish me to do so.
My question stands unless it's a improper recitation of the law, but
Well, if juror H69 has a question about what the law says, I don't want either side to give an interpretation of the law. If you have a question as to what the law says, I would be more than happy to read the instruction again.
No, I don't have a question about the law. I just wanted to make sure I was understanding the question he was asking.
So, if you have a reasonable doubt as to whether or not self-defense exists, what would your verdict be?
If I have a reasonable doubt that self-defense does not exist,
Or exists? Let's start there. I was going to go to the next one, but I want to try and start it. It's a reasonable doubt as to whether or not self-defense exists. What's your verdict?
I'm sorry, I'm trying to make sure
I
I'm
know.
understanding the
No,
question.
it's a concept.
It's not a concept, it's tricky, because if self-defense did exist based on the evidence that is presented, I do not have a doubt that he did act to defend himself or anyone else that was around him. I don't know the situation. Then I would have to say he's not guilty. However, if self-defense is not proven, it's not evident, it's not clear, and I have no doubt that he just used brutal force because he wanted to, then he would be guilty.
Okay. I'm going to read that portion of the instruction and then we'll move on because I don't want to go back and forth into an area the court doesn't want me to go into. So I'm going to read it to you and see if that clarifies it, okay? If in your consideration of the issue of self-defense, you have a reasonable doubt as to whether or not, reasonable doubt on the question of whether the defendant was justified in the use of deadly force. Got it? If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether the defendant was justified in the use of deadly force, you should find the defendant not guilty.
Right.
And I would object to this time I made. He's not reading the second paragraph.
Please give me the instruction again, and I will read the entire instruction so there's no confusion on the part of the potential jurors. The entire instruction. I'm not singling out any part of the instruction. I think that if there is a question as to the instruction, so I need the other page.
I only wrote that because of one last sentence, which I was about to get to, if you want.
I don't want anything taken out of context when it's coming from the bench. To keep this in context, I will read the instruction to you again. Justifiable use of deadly force. An issue in this case is whether the defendant acted in self-defense. It is a defense to the offense with which George Zimmerman is charged if the death of Trayvon Martin resulted from the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent 1, imminent death or great bodily harm to himself or another, or 2, the imminent commission of aggravated battery against himself or another. Aggravated battery is intentionally touching or striking another against his or her will, and in committing the battery, intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to the other person. In deciding whether defendant was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, the defendant must have actually believed that the danger was real. If the defendant was not engaged in an unlawful activity and was attacked at any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or to prevent the commission of a forcible felony. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of the defendant and Trayvon Martin. If, in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether the defendant was justified in the use of deadly force, you should find the defendant not guilty. However, if from the evidence you are convinced that the defendant was not justified in the use of deadly force, you should find him guilty if all of the elements of the charge have been proved.
Thank you, Your Honor. Does anyone on the panel have a problem with it being the, yes, sir?
I heard the phrase forcible felony.
Yes.
I suspect it has some actual definition.
Just so you all know that the court is not going to define other than what's in the instructions. The court will not define any other terminology for you. I understand what we're reading to you may not be something that you can look at and dissect. Please understand that if you are on the jury, a written copy of the instructions the court will read to you will be brought back into the jury room with you so you can read them, discuss them, and amongst yourselves and come up with your own decisions. Does that help? Okay, and you, no, well, you're saying, okay, I want to make sure that helps.
G63.
You're juror G63. Does that help?
Yeah.
Okay, thank you.
Thank you. Does anyone on the panel have a concern with it being the prosecutor's burden to prove that it was not self-defense? Anyone have a concern with that? Sir, do you have any problem with it being the prosecutor's burden to prove that Mrs. Zimmerman did not act in self-defense?
No, sir, I don't have a problem with that.
Okay. Anybody, ma'am?
That was juror.
B35.
Thank you.
There was some questions raised yesterday about physical disputes, and I know that several of you raised your hands, and I want to talk to you about those. There may be some of those that you would rather have this discussion outside the presence of the rest of the jury. On limited occasions, we can accomplish that, particularly when they're really personal matters, and this may be. So if I come to you, I'm going to ask for a raise of hands. I think I have some notes, but I'm going to see if we can talk about some of it in the whole group, because I think that we may need to. So with that, sir, I think that yesterday you had said that you were involved in a physical altercation back when you were younger. Is that right? Okay. Was that, I think you said it was in middle school?
B7, yes, it was.
Thank you. Tell me a little bit about that, a little bit about that experience.
Let's see, it was 6th grade. Wow. I'd like to think that I got in a fight with a bully,
Mm-hmm.
but it might have been possible that I was the bully.
Okay. That common sense at 5 and common sense at 65 thing?
Not
Okay.
65.
I didn't say you were yet. I didn't say you were yet. And you weren't 5 in 7th grade either. Just throwing out the concept. Let me ask you this. Did you get hit in the face?
Yeah.
Okay. All right. It obviously stuck with you long enough to mention it yesterday.
Well, it's the only fight I've ever been in my life.
Okay.
So I remember it.
If there is evidence of a physical confrontation here in this case, would your experience back then sort of drip over onto what happened here?
No, I barely remember it.
When the event happened, have any problems with the memory of it back then? Any problems remembering what happened even back when it happened?
Oh, no, I remember when it happened. It's just, you know, as you get older, memories fade.
And then I think going down the road, I think you had said that you'd been involved in, I think your words, I think was only a couple of fights when you were younger?
Yes, when I was younger, and one just a few years ago, trying to collect rent in one of my properties.
Okay.
I got attacked by one of the guy. I'm sorry, B35. Okay, I'm sorry, yeah. I was trying to collect some rent a few years ago, and the young lady moved some guy into the house, and it wasn't in the lease, and I was talking about it, and he hit me. And so we tussled, and
Okay.
I had to beat him down. He ran and grabbed a butcher knife, and I ran in my car and grabbed a bat, and we stalemated. And he was making a house, and I just sat in front of the house and called the cops.
Okay. Did he sucker punch you?
Yes.
Didn't know it was coming?
No, I didn't know it was coming.
Where did he hit you?
Right there.
Caused bleeding?
No, I think he was kind of stunned that it didn't affect me because I looked in his eyes and saw him. Looked after he hit me, and I just grunted a little bit and looked like at him and started firing back on him.
Okay. Again, if there's a physical confrontation discussed in this case, would your experience with that, and we'll talk about some others in a minute, with your experience with that affect your ability to just look at the facts of this case and apply the law to this case?
Not really, because that was my own personal experience. It had nothing to do with this.
Okay.
No,
Okay. A couple of the other fights you were in, I guess when you were younger, were they sort of similar?
yeah, some were similar, some were actually a little bit worse, but pretty much along the same
Okay.
area.
you say worse, just worse result for you, or?
Yeah, I got beat down and I won a few, lost a few, but it is what it is.
Okay. Tell me the common experience of being in those fights. What was going on with you and your body?
Well, it's like you don't really realize what's going on. I know I didn't. Some didn't realize what was going on. Just basically thinking about myself and not feeling what was coming on me, and just wanted to get out of it and make sure I was all right when I get out of it. So I would do what I had to do to try to get out of it and make sure I was all right. That was basically the adrenaline rush going, and I didn't feel anything until after it was over.
Mm. I know that there were some other people who had some events. So sort of going down the first row, ma'am, did you mention that you were involved in a domestic violence event?
Yes.
Okay. And again, these are very personal areas. I don't want to delve too close into it, so let me try it this way. We've heard these two jurors discuss sort of how they reacted to the event of violence in their lives. Did you have a similar reaction or experience to it?
Well, one thing you mentioned about losing memory of, I did lose bits and pieces for a little while, and then things came back to me.
Okay. Did that come back over time?
E6.
Did that come back over time?
E6. It's an E6.
Yes, you're E6. I do remember that.
Yes, it came back to me later.
Okay. Anything else that was either similar to what either of these gentlemen said about the experience of being involved in a violent act?
Well, it's just a completely different situation, and it really doesn't seem relevant to me at all. I mean, it wouldn't even,
Okay.
and yeah, I wouldn't have any way to compare it.
Okay. And I appreciate your willingness to talk about it here. I know that bringing up any bad experience, particularly a violent one, but I appreciate that. My understanding is, I think, ma'am, that you also had an event that may have even been closer or more specific. Is that accurate?
It is.
And your number?
E73. My nephew was shot and killed.
Okay. How long ago was that?
13 years.
Was it, I'm going to say it as though, was it an event where the police got involved because of the shooting?
I'm not sure I understand why you're asking.
Well, I guess, you know, those true accidental shootings that might happen, and there are those.
It was a home invasion. He was shot through the door. He was an innocent person sitting at a table.
Okay. So in effect, completely random. And they came to his house rather than some other.
That part I don't know.
Obviously, we're talking here about a case where somebody was shot. Circumstances much different than that, but do you think that memory of your nephew's passing from 13 years ago would make it such that you would not be able to set that aside and decide just on the facts that you hear today?
I would hope so.
Well, let's talk about that a bit more. We talked about pretrial publicity, for example, which is nowhere near the level of emotional attachment that a family member's passing is. So, pretrial publicity, we said you can hear it, you don't know if it's accurate, you don't know if it applies to this case, you have to exclude it. And I think you said that you could, right? And we've talked about the standard that we have here, the state's burden, and that the evidence has to come from that witness box right behind you or physical evidence that you see. And that you have to decide only on that, and that you have to apply the law to that evidence, right? So, can you do that? Granted, you have a life experience, like a traumatic life experience that is somewhat similar. But can you set aside or just make that life experience part of your growth and common sense that we ask you to bring with us, but not focus on your nephew's passing as being an overriding influence on what happens here?
I'd say I'd hope to, but you know that it's always there.
Sure.
An unarmed young man is shot.
Right.
And killed.
Okay, and I appreciate your willingness to share here as well. There were, I thought, at least one other person who had a violent experience in their past. Did I not have that right? Somebody said yesterday? Oh, did I pass over you? I'm sorry.
86.
And again, this is something where, if need be, we can talk about it, but I just want to make sure that we talk about that experience so it doesn't do what, this juror was talking about. It may have some impact. So tell me about that.
I worked at a fast food restaurant where somebody came in and robbed us at gunpoint.
Okay. Twice? Or you
Twice.
said?
I was there both times.
Okay. Would that impact your ability to sit here? I think you said it would not,
No.
all right? Any concern with being able to set that aside?
No.
Okay. And then ma'am right behind her?
K95. I don't really know if it's relevant, but I had an old boyfriend who broke into my apartment, and so I...
Okay. Sure. Were you home?
Yes.
Okay. Was there violence on you?
Yes.
Okay.
And on him.
Okay. I don't want to make light of it, but...
They did call police, I said yes.
Okay. You heard the woman in front of you, E6, talk about in a moment of that type of event, there's sort of a memory loss or not remembering everything. Did you experience any of that?
No, sir.
Remembered it? Okay. And this juror here, 35?
Yes, 35.
My first one. He had said that in a couple of the altercations that he had, you sort of, your focus comes in. Is that sort of right on just what's going on?
Pretty much, you're just in the flow. You don't really think about, well, I didn't think about going on, but just trying to get out of it.
Okay. Did you have any experience like that?
Yes, I did. K95, I had the fright flight where I just went out and I kicked his motorcycle over and locked him out of my house, and the police came.
Okay. Kicking a motorcycle is not easy.
You just get strength that you don't know where it comes from.
Okay. And that was based upon the threat to you?
Yes.
Also, there were some conversations yesterday about fitness and people who involve themselves in fitness. And I do remember, sir, in the back, your number? Yes. That you had involved yourself sort of ongoingly in a lot of weightlifting, tennis, and swimming?
Yeah.
Okay. His number is H18. Sure. I'm going to try something that may not work out, but the gentleman to your right there, your number?
B72.
B72. You may have heard that he does a lot of arm wrestling. I'm going to continue both athletes, just because, well, honestly, the way you look, and also what you've told me about what you involve yourself in. Can you pick out an athlete in a room, you think?
I could tell who does
Okay.
take care of themselves. Yeah.
What do you think? You look around, sort of pick out the athletes?
I disagree with that. I've seen some people who look like they're not strong at all do the most incredible things. My one friend in particular, skinny guy, you never think you have it in him. And he's just a beast, so I don't go around and say, yeah, who give me a run for my money, or I can take them.
Okay.
I think it's bad to do that, especially before a match or anything like that.
Sounds good. Who's played football? You play football? You play football? And you play football? Okay. What position?
I was all the way around.
I'm sorry, your number again.
I'm sorry, age 29. Fullback, split end, defense, offense.
You learn how to give a hit?
That's Absolutely.
You learned how to take one?
Absolutely.
What about you in the back? What football did you play? What, there, yeah, with the gray. Yes, sir. Your number? That's you.
B72.
Yes.
Ditto. I did just about. You got some hits, you take some hits. More offensive than anything.
Okay. All right, sir, up front, you play some football?
Yes, B7 in school.
Okay. What positions?
I was always slower, so I'd be up in front, along the line.
Okay. Again, learn how to give some hits and take some hits?
No, it's flag football.
Oh, flag football? Okay. You were,
You didn't specify when you asked.
no, football is football. With a physique like this, I played flag football too. So I know where you're coming from. There were some conversations about neighborhood watch, and there was a hands raised about those people who live in communities with neighborhood watch. Would you raise them again? Okay. Those and everybody else, neighborhood watch, good thing or bad thing? Good thing or bad? Good. Everyone says it's good. Who thinks it's a bad thing? Okay.
E40, I'm not saying it's a bad thing. I'm saying it needs to have the parameters defined of what their purpose is, as what their goal is, and just sort of what assumptions they're going to work under, then to know if it's too much or not enough, or if it's serving the needs of that community in which they are doing the watch for.
Sure. What do you think the general purpose of neighborhood watch is?
I would believe it is to keep your eye out, to be alert, to be attentive to things that are maybe different. If, cars are parked maybe too long, or people who might be in that area that maybe don't belong there are trespassing, or maybe are soliciting, and you're not supposed to be doing that. So it's a balance of what the rules are versus maybe having a way to keep your eye out to see if those rules are being met or not.
A watchful eye to see if something is amiss?
Yes.
Okay. Does anyone disagree with that? Yes, sir, ma'am.
I don't totally disagree. I-24. It can be a good thing if the entire community is involved in it. It can be a very bad thing if they're not. When you have one or two people who are very diligent in making sure that their neighbors are safe, there's an imbalance there.
I'm not sure I follow you. I understand what you're saying about an imbalance, because does that mean that just 2 or 3 people are taking on all the workload? Or,
sometimes.
Okay, so you feel it needs to be more?
Everybody needs to get involved. Everybody needs to be involved in assisting it.
Okay.
We had, in my neighborhood, where a house was empty, it was broken into, and there were like copper wiring taken and other things like that. And I did see a truck in another house that was empty, and they were taking things out of the house, and I took a couple of pictures of the truck. But, people thought I was being silly.
Okay, is that sort of the concept of one watching out for the whole? And then the whole watching out for the one?
Yeah.
Do you think that's a good idea to have in a community?
No. I think everybody needs to be involved. Everybody needs to understand that it's very important to watch out for each other, to make the community safe.
Anyone disagree with that? Yes.
I agree to a certain point, but I think yesterday there were quite a few that mentioned that, yeah, we have a sign, but I don't know if there's actually people that are there. And I think, if nothing else, at least as a deterrent to criminals, because I think criminals go out and they choose who are your easy targets. So there might be one neighborhood next to another, one with the Crime Watch sign, and they're not living there, they don't know how active they are, versus one that doesn't have the sign. That could be a deterrent. So I don't know the level of involvement that really even took. And I know that's not gonna deter all criminals, but those are my
Okay.
thoughts.
But-
for B61.
B61, I apologize.
As a concept, does anyone disagree with the idea of having neighbors watch out for neighbors? Okay. For those people who are in gated communities, one more raise of the hands just so I can pick on someone. Great. Do the police patrol gated communities less because they're gated? Is that your experience, ma'am?
Sorry, me?
I thought it was you with the blue. Did you say that you were in a gated community?
It's
Yeah.
an apartment complex, the gate is always open, so I
Okay.
don't know if that's.
Sir, how about you?
H81. Our community is actually manned part-time by deputy sheriffs. So
Oh,
it's
okay.
not a fair, probably not a fair
Agreed.
example.
All right, then you get off the hook. Somebody else in a gated community? Yes, ma'am.
I don't really know if they, I know I have a cop who lives in my gated community, and there's a lot of people who park wrong that irritate me, and they haven't had anything done to it, so I'm gonna assume no in my neighborhood.
That's your I-19.
And there was, I'm going to now start doing the bouncing around a little bit, but what that indicates to you is that I'm getting very close to being done. So at least we'll get you out to lunch here pretty quickly. And I'm at the edge of the time that I said it would take me as well. So we're going to get close to the end here in a few minutes. We did have some conversations earlier about firearms, and I want to talk about that for just a minute. I think that one of the people said yesterday that there is a responsibility that comes with firearms. Does anyone, again, it sounds overly simplistic, does anyone disagree that if you're going to have a firearm, that you should use it responsibly? Okay. And so I think you mentioned that you have a concealed weapons permit, right? Does anyone think that those who have a concealed weapons permit should not? Raise your hand. Should we, those who have a concealed weapons permit, just shouldn't? We don't need people carrying guns. Sir?
B7.
Okay.
I'm really concerned about the proliferation of handguns, knowing throughout our country and the number of shootings involving them.
Okay.
I'm not comfortable with the sort of wild, wild west attitude.
Okay.
I don't want to live somewhere where people are just walking around and carrying guns. I don't feel comfortable around them.
Talk to him.
Well, I know he doesn't have one right now. But if he did, I would be very nervous. And I will admit, even with the utmost training, through this jury selection process, I've been surrounded by armed deputies. And
that concerns you?
And even that gave me creeps.
Okay. Firearm. Does it bother you that I have it?
How's
Not
that a
really a
firearm?
firearm, but we're going to make believe, because if I had one, he'd have me in cuffs.
Okay. So
Firearm.
So you're pretending that's a firearm.
You worried?
Yeah.
Okay. Who's worried? I have a firearm in my hand. It's really okay to be worried if I have a firearm in my hand. If you are, don't make it up for the story, but if you are, people having firearms, who troubles you? Here. How about now? It's in my pocket, but you know it's there. Who's concerned? Why?
Okay, I don't know you.
Okay.
I don't know how responsible you are with that.
Correct. What if I was able to show you, with this help, a concealed weapons permit? Let's make believe my car that gets me in the Orange County Courthouse is a concealed weapons permit. It's not, but let's make believe it is. So you know I have this.
Okay.
Still concerned?
By the way, I'm E54, I'm sorry. I feel a little better.
A little bit better?
But,
Okay.
but I still don't know you. I still don't know how
Right.
responsible you are, even with that card in your pocket.
Right, okay, legitimate. Who else has concerns? This is a firearm, it's in my pocket. Ma'am?
E40. I guess I'm neutral on it. I don't know enough about concealed weapons and getting a permit for it, so I don't know the validity, credibility of all that piece.
Okay.
But as he had said, I don't know you, I don't know your intentions, I don't know why you have a firearm or wanted one, and I know I don't, so I think that makes me, again, like, B7 said, just a little bit less easy.
Okay. You've had firearms, right? Didn't you have a concealed weapons permit?
I did.
That expired?
I did.
So if I handed you my loaded gun and asked you to unload it for me, would that be okay? Can you do it?
Well, not in a situation I could do it.
Okay.
That's P35. Oh, sorry.
Okay. Who else has concerns? Ma'am?
Sorry, that was B37.
37.
B22.
Yes.
I would be concerned because even though you have a permit for it, it tells me that the state knows you have it or some governmental entity knows you have it, but it doesn't tell me what you might do with it. So if we're in a room together and you see something and you draw your weapon, that would make me nervous.
I still have to act responsibly with it, right? And you don't know if I'm going to or not. Is that the concern of most people? Yes. Okay. All right. Yes, ma'am.
My concern is, you have a permit to carry a concealed weapon, which means, I-24, which means, you're taking responsibility and saying, I want to carry a gun, telling the law that you carry a gun.
Yes.
Okay? So there's nothing you're trying to hide. What about the people, and there's a lot of them, that are running around without a concealed permit? Those are the people I'm concerned about. Those are the people that are trying to hide something. And that's where my concern is.
Sure. And that's crime, right?
Mm-hmm.
Okay. So you don't know which are which yet, right? And that's the concern that you have?
My concern is that there are too many people that carry a gun that don't have a permit.
Here's the point that I want to see if you could.
How do we stop that? We don't. We can't.
If in fact there's evidence of the carrying of a firearm, concealed, with a permit, with that fact alone, the fact that we're talking about a firearm, I'm going to put mine down so we don't have to worry about it. So if evidence comes out that there is a firearm being carried concealed with a concealed weapons permit, will that fact alone cause you such concern that it would infect or impact on how you would handle this case? Nobody? Nobody at all is that worried about guns? Yes?
The only concern I would have is if I observed them not being responsible with it in my presence. But other than that, they've done what they were supposed to do legally.
Okay. The real question is, in the facts of this case, not that there's going to be a gun in this courtroom, but in the facts of this case, if you were to look at the facts, would the issue or the fact that someone had a concealed weapons permit and carried a gun be a concern of yours, such that it would override, let me just finish the question if I might, that it would override your ability to be fair and impartial?
What is the objection? Objection is to getting into the facts and getting your commitment from the jury's response.
Sustained.
We had talked a little while ago about witnesses and law enforcement officers, and I think Mr. De Leon said, whether you're unemployed or a law enforcement officer, will you treat that witness's testimony the same? And I think everybody said, of course. I'm going to ask you to modify that to the extent that you agree that what I read earlier about potential bias or ability to understand or ability to see what they testify to, would you agree that those are considerations you would have on who to give credibility to or weight to their testimony. Did I say that in as confusing a way as possible? Okay, great. I'm going to try it one more time. When Mr. Del Rionda said, you should just look at a witness, whether they're unemployed or a law enforcement officer, and give them equal weight. And you said we should, right? And we will, correct? Yes.
37, you really can't unless, I mean, if they're like an expert.
Okay.
I mean, they would have a little bit more credibility than just the average Joe that went out and gave testimony.
Okay. Let me ask it this way. Will you all agree, I'll ask it this way. Will you all agree to assess the weight that you give a witness's testimony on those factors we talked about, which is opportunity to see it, maybe their bias in what they do? Any concern with that? Yes.
Seven, I have a question. Law enforcement officers consider expert witnesses?
No. I can't tell you much about that, but unless they are presented as an expert within the field of law enforcement, and the judge says, listen to them, they're an expert, no. Law enforcement officers, when they come in to testify and said, I did this, they're just fact witnesses, what we call fact witnesses. Yes, ma'am.
I think it works a little bit backwards in how you're saying it. First, I have to listen to the witness testimony, figure out if there's bias and how it falls within the timeline of what everyone else is saying. I mean, if they're saying something radical than what everyone else is saying, then I might not weigh it the same as everyone else. So it kind of works a little bit backwards. So I understand where you're getting to, where people have bias and we have to weigh the information we get in different orders for different weights. But I think it works a little bit backwards than how you were saying it.
Okay. It won't be the last time I'm being confusing during the trial, so I'll try not to be, but certainly you'll take all of the witnesses' testimonies in context to everybody else's. Is that what we're talking about?
No, about your previous question.
I want to forget that one. It obviously wasn't working. But you agree to take all witnesses' testimony in context with the other witnesses that you hear? Any concern with that?
No.
Okay. And of course, with the evidence as well. Okay. There was a question by the prosecution yesterday about whether or not a 17-year-old's life is worth less than somebody else's. And you all answered no, of course. And then we talked about black lives, I think, as well, worth less than whites or something. Does anyone have any residual concerns that any of the external pressures that may exist in this case would be able to affect your ability to sit as jurors? Anybody? Because this is truly, I'm near the end, and this is the last chance that we're going to have to find out what you're going to bring back to the jury box with you. So any concerns at all about that? Do you think the corollary that because it was a 17-year-old's life that was lost, that should be given special consideration over and above what you would give if he had turned 18, or if he was 28, or even if he was 78? Any thought about that life having been lost should be given any special consideration because he was 17? So what do you think about that?
No, I think everybody's equal in the law, so no, I don't think anybody should have any preference.
Okay.
That's true.
Sorry, E54, yes.
And that similar, it was a black life that was lost rather than any other race. Any special consideration that should be given to that?
No.
Anybody?
No.
Okay. I said it was unique earlier because I think it is. I like it on this side of the world, that side, it's a little unique, and part of it is that we, as human beings, constantly make immediate decisions and assumptions. We talked about that earlier. In this unique set of circumstances, you are told affirmatively not to do that. So I'd like to have one person tell me that it's going to be difficult for them to wait until the very end of this case before they start getting a feel for what they think should happen in it. Somebody acknowledge that it's going to be tough to wait until the end, that you're going to go through the first day of testimony and keep your mind open, that you're going to go through the second day, maybe the second week of testimony, and intentionally and affirmatively keep your mind open to wait. Since you're looking down, I'm going to ask you, ma'am, if you would tell me your number.
E28. I think as human beings, it will be difficult for everybody not to probably have some form of opinion, but that doesn't necessarily mean they can't, look at all the facts and come up with what is right.
Anybody else have concerns with being able to wait until the end? Yes, ma'am.
B12. I don't know if I was like concerns, but I think as we will be weighing the evidence daily as we're getting it, and I don't know if we'll be forming an opinion, we'll wait to the end to give our full opinion, but I know we're going to be taking the evidence in and going, okay, and then if it's not going with the evidence we got the day before, you'll kind of be thinking in your head. Yeah.
We're not going to ask you to be robots. We talked about that earlier. My only concern is that, well, first of all, of course, that you cannot discuss it with the other jurors until we're done. I mean, that's easy. You can't say that two people on the jury, well, what do you think about witness A? That's easy, and the judge will instruct you to that. The concern is you want to make sure that even in your own mind, you listen to witness A and go, oh, okay, I got it. Witness A pretty much cleared it up, and there's witness, W yet to come. Make sure that you withhold making that decision, because my concern, when you make that decision, it's harder to get away from. It's that assumption. It's that people are going to drive down the street and stay in their lane, that you sort of miss the constancy of watching what's going on around you, right? Can you agree to that?
I can agree to that, yes.
Can everyone agree to two things? One, that it's going to be hard to do, yes or no?
Yes.
Yeah? And then two, will you still do it?
Before you get into another topic, and this is in no way to restrict you from going on further, but it's now 12:42. That's the time that we broke for lunch yesterday, and I have 40 people sitting here who have not had anything to eat since 9 o'clock, and I can hear some stomachs rumbling.
I'm going to get them to lunch with my last words within a minute.
I don't want to restrict you.
No.
You can have time after lunch.
I said earlier that I was about done, and I'm going to be about done.
Okay.
So truly about done. It's easy for you to get to this question, but I always say it first. Can you assure, of course, that you'll give the state attorney's office in their prosecution a fair trial? Okay. If in doing so, that is an acquittal, if we tell the state attorney's office that they simply have not carried their burden of convincing you beyond and to the exclusion of every reasonable doubt, can you also say that to the Martin family? Because by your verdict you would be. Concerns with being able to say that? Yes.
I feel a little bad about the loss of their son and everything, but that's what I believe, that he was not guilty of murder. That's what I have to state, but I still feel bad for the family's loss.
Okay. And can you give George Zimmerman, the focus of today's trial, can you give him a fair trial? Can you tell the state that they will only get their conviction if and when they convince you beyond a reasonable doubt?
Yes.
Nothing further on. Thank you.
Thank you very much, ladies and gentlemen. I'm going to send you to lunch. Again, I'm going to give you my instructions. When you go to lunch, you're not to talk about the case amongst yourselves nor with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to get on the internet by using any type of electronic device to do independent research about the case, people, places, things, terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or posts, or social posts about the case. Do I have your assurances, each and every one of you, that you will abide by these instructions? Yes. And raise your hand if you cannot abide by that instruction. No hands are being raised. We're going to have to do some work without you. So I'm going to give you an extra long lunch hour so we can eat some lunch, come back, do a little bit of work before we bring you back. So if I gave you an hour and a half, it's 12:45, so 1:15. If you all will be back here, start gathering about, that's 30 minutes. I can't tell.
We are paying attention.
2:15, or start coming back between 2 and 2:15 so we can get you back in the rooms and we can proceed. Follow Deputy Jarvis outside of the courtroom. Please be seated. We have the Fry hearing coming up at 2 o'clock. I do not want to keep these jurors back here all that time. So I know that you all need to discuss amongst each side about how you want to proceed with the jury selection process as far as doing your strikes. So would you be able to have lunch in a half hour's time and be back here and get that discussed? Well, Mr. West, we were going to have the Fry hearing yesterday, and you requested that the Fry hearing be held off till today. And I don't know that the witnesses available is beyond 2 o'clock. And I would like to complete that Fry hearing so the court can issue a ruling, and I can't do so until we finish with the testimony. So I've got to have some take from you all as far as time also to get all of this accomplished. So you tell me how much time you think you're going to need for us to reconvene here and go over the jury selection process, or finish the jury selection process. All the questioning has been done. It's just the preemptory strikes or any strikes for cause that needs to be completed.
Your Honor, since the court asked, I would suggest an hour and 15 minutes so that we can have something to eat and that we can also discuss among ourselves how we want to proceed.
Okay, court is in recess till 2 p.m. That gives you the hour and 15 minutes. Go ahead, get something to eat, have your discussions, and be back ready to discuss challenges to the jurors. Thank you all. Have a good lunch.